having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. Welcome to the Massachusetts Appeals Court on this Tuesday, July 1st, 2025. Happy Canada Day to those who celebrate. This is the 490th anniversary of Thomas More's one-day treason trial. It might be setting a low bar, but we intend to do better than justice was served in that day. I'm Justice Joseph Ditkoff. To my right is Justice Catherine Hand. To my left is Justice Marguerite Grant. And we're the panel for all the cases here. I see we've got a lot of interns and distinguished persons, and we welcome you all here. For the interns, we'll be meeting after the arguments, and we'll come off the bench and talk to you, so please stick around if you can. For the lawyers, I know we got some new people here, so the clock will count down 15 minutes. It'll show green. When there's 90 seconds left, it'll turn yellow. When time runs out, it'll turn red and start counting up. The numbers when it's red are not how much time you have left, it's how much time you're over. So if it turns red, finish your sentence, but don't say anything else unless you're answering a question from one of the judges, in which case please do continue your answer. I assure you we've read the briefs, we've looked through the record, and you'd best serve getting right into your argument. Before I call the first case, ADA Marshall?
Yes, Justice.
Could you approach, please?
Yes.
Just come up to the... have you discussed with Attorney Maloney the import of the letter you sent us last night or this morning?
I have, Your Honor. I sent him the letter last night at the same time I sent the court, and me and him did have a conversation this morning prior to coming into session.
Excellent. Okay, that's what I wanted to check. You can return. If you hadn't, I was going to suggest you do that before argument starts. Since you're going second, it wouldn't be very fair if you didn't have an idea of what was going on. That's excellent. All right. So with that out of the way, I will call our first case, number 24P 1147, Commonwealth versus TARTAGLIONE. And I want to assure everyone that we have watched the video. You can be assured of that. Whenever you're ready, Counselor.
Thank you. Good morning, Your Honors. My name is Corey Arter, and I represent Christopher Tartaglione in this matter. As Your Honors are aware from your review of the record and the video, this case arises out of an incident on May 6th of 2023 in Bridgewater, Massachusetts. Mr. Tartaglione was charged with threatening to commit a crime under 275 Section 2. This should be a fairly simple and straightforward argument. This one issue on appeal. It's the sufficiency of the evidence as to one of the elements of 275 Section 2. While I do understand Your Honors have read the briefs, if you would permit me just very briefly to point out a couple of the key facts which I think are important. Thank you.
If you'd like.
By way of very brief background, Mr. Tartaglione rented a room from the alleged victim, Mr. Johnson, for several years. There was some contention between the two as he was attempting to evict my client. On the date of this incident, on May 6th of 2023, my client came into his home to go up to his room, and the alleged victim's wife approached him with a dog on a leash and attempted to come near him and his dog. The incident was witnessed by the alleged victim, Mr. Johnson. Mr. Johnson was unhappy with the interaction between my client and his wife and approached Mr. Tartaglione. As he approached Mr. Tartaglione, he's holding a steel-toe boot in his hands. He lunges towards him holding the boot, threatens him, tells him to, and I will paraphrase, shut the F up. Again, just for purposes of the actual threat that is made, I'll again paraphrase. Mr. Tartaglione responds, that's an assault, you're assaulting me, go right ahead, I will beat the F out of you, okay? Tartaglione then backs up. The alleged victim then rushes towards him twice, and I'm sure as you could see in the video, attempts to headbutt him twice. Mr. Tartaglione then again backs up and ultimately leaves the area. 275 Section 2 requires that the Commonwealth prove beyond a reasonable doubt 4 elements. The first 3 are essentially not in dispute for purposes of my argument today, that there was indeed an intent to injure communicated, that it was conveyed to the defendant, and then if indeed the injury threatened was carried out, it would have constituted a crime. There's no doubt that had Mr. Tartaglione beat the blank out of Mr. Johnson, that would have constituted a crime. The issue is not with the first 3 elements of this statute. The issue is with the 4th. The 4th element of the statute being that the defendant made the threat under circumstances which have reasonably caused the victims to fear that the defendant had both the intention and the ability to carry out the threat. I would suggest to you that the evidence was insufficient on that element of 275 Section 2.
Why, Attorney Arter, given the fact that the defendant didn't leave but remained engaged in this argument with the victim in this particular case, why doesn't that suggest that he actually did have the intention, and then we can get to the ability later, but the intention to make good on those threats based on the fact that he stayed and remained engaged in the escalating verbal fight?
I mean, that's a good point. As I'm sure that you observed in the video, this was a very brief interaction. There was words exchanged. At the point that Mr. Johnson is the aggressor and is coming towards him, he does indeed stand for a moment and respond verbally. Again, this case arises out of the verbal interaction. However, under Commonwealth v. First, it is clearly settled that menacing words alone, even those that may threaten a crime, are not enough in and of themselves. The court's got to look to the whole entire context of the interaction. These are people that lived in the same home together. He was going to his room in that home. This is an interaction that, according to the testimony, had been going on for some time during this attempt to evict Mr. Tartaglione from the home.
So are you interpreting that 4th element, defendant had both the intention and the ability to carry out the threat, when the defendant has said, I'm going to beat the F out of you, and I think I'm going to effing kill you, that unless the defendant has some sort of a weapon, then that can't be a threat because he doesn't have the ability to carry out the threat?
Oh, no, absolutely not. I mean, taken in isolation, those words absolutely could be deemed as threatening, the words themselves. However, under Commonwealth v. Shawley and First, the court needs to look to the context in which the words are said to determine whether or not the victim believed that Tartaglione had the intent and the ability to carry out those threats, as opposed to them just being...
Why wasn't that the jury's role?
Again, there are 2 parts to the appeal, obviously, on the sufficiency of the evidence as to whether or not the motion for a required finding should have been allowed by the judge, and or that the jury erred in that there was not sufficient evidence. Here, the evidence supports that based on the testimony, based on the video, based on the history between the parties, based on the totality of the circumstances, these are parties who had these similar conversations regarding this exact same thing in the past. I think perhaps most telling is Mr. Johnson's own testimony. Johnson, when asked, was he in fear, says, well, somewhat. What I really think happened here is this guy instigated the whole thing. He really wanted to create this issue between us, probably to gain favor in his eviction proceedings. The officer who testified said he similarly asked Johnson, were you in fear? And he didn't. He didn't say that he was. Additionally, looking at the context in which the statements were made. I mean, Johnson was ultimately convicted of assault and battery with a dangerous weapon. That was known to the court and to the jurors at the time of this thing. So quite clearly he is the aggressor. He commits the assault with the boot.
Just
again,
assault.
attempts with the head.
Just assault.
Assault, yes. Again, with his attempt to headbutt. In the context of this, it was not Mr. Tartaglione who came in with the intent to come in and threaten him. This case is factually distinct from Counterman, cited by my sister, wherein they say, well, you got to look through the subjective understanding that there's a substantial risk of the statements. In that case, it's a long history of the defendant being the aggressor. It's a domestic relationship. He was yelling for hours at the victim and then says, I'm going to punch you in the face. It's a completely different factual pattern.
That argument, Attorney Arter, that you're just making now, that despite the fact that Counterman, the instruction on the fifth element that Counterman
Sure.
and Cruz imposed here wasn't given is of no moment because there was no other conclusion that one could draw besides the fact that the defendant intended the victim to understand he was using threats?
Yes, I think that my point in that is the point raised by Shawley, is that it's not the words alone that are said. So similar to Counterman, there is a statement made here that if carried out would in fact have been a crime. That I'll punch you in the face statement in Counterman, the statement here, I'm going to beat the F out of you. In the context, the statement's made in response to actions by Johnson. The statement is not made affirmatively, unlike Counterman, who has a history of those several hours of him screaming, yelling outside the house, then saying, I'm going to punch you in the face. I think that, while the evidence does not need to show that Johnson was in actual fear or was in fear, it's something that the court should consider in the larger context. Under Commonwealth versus Winter, it's probative as to whether or not the state of mind of the victim is probative, as well as the state of mind of Mr. Tartaglione when making it, as to the intent and the ability to carry out the threat. Winter and Shawley both say you've got to look at the whole circumstance. You can't just take that statement in isolation. Interestingly, in this case, looking at the totality of the circumstances, I don't think there was sufficient evidence. My sister apparently, and much to my surprise, appears to recognize the deficiencies in the case, because what she's asking for relief here is not that the judgment be affirmed, but rather that it be vacated and sent back down for another trial.
On a discrete basis, not on the sufficiency of the evidence. In fact, just the opposite, saying that there is evidence not only of the four elements on which the jury were instructed, but also on the counterman.
Yeah, and so what they would suggest is that it be vacated and sent back down. I would suggest, Your Honor, that based on the insufficiency of the evidence, that if it were sent back down, they would be in exactly the same position, that they haven't met their burden on the fourth element of the case. There's no need to have this retried again. The evidence is what it is. The video is perhaps our best evidence that shows the posture of the parties and the fact that Mr. Tartaglione was in a defensive posture and backing away and ultimately removed himself from the situation.
Well,
thereby, again, going to intent.
If this case were retried, would the Commonwealth be able to introduce your client's testimony from the first trial, including, I was trying to prevent him from aggressing towards me, my purpose was to fend him off, I was trying to keep somebody from striking me? Would that come in at a second trial?
I think that it can, and I don't think that, and I agree in part that I don't believe that double jeopardy attaches clearly if it's vacated and remanded. Since it is a statement under oath, I believe that it could come in. But again, even if it were to come in exactly like that from the first trial, I still think it shows it wasn't his intent as an aggressor to come towards him and to say to him, this is what I'm going to do to you in the future. You have to look at the context in which the statements were made. Again, it's his attempt to tell him to back off from me, meaning, so that statement that you mentioned, and that you mentioned from the trial, that his intent was not to harm him. His intent was to defend himself, in which he ultimately did by backing up, flinching, and the video is very telling, and then leaving the scene and calling the police.
If his intent was not to harm the victim, but to make the victim think he was going to harm him, would that be enough?
I don't think so, not in this context, because again, you've got to look at the words in the statement in the context of the whole situation. Under Shawley, you have to take everything in. So if his intent and his statement is, I wanted to say this to him because I was afraid I was going to get hit by this boot, I wanted him to back off. If his intent is to back him off from him, to show that he's standing his ground, I don't think that's an intent to harm him now or in the future. I think that's a defensive intent. And again, I don't think that rises to the level.
He doesn't need the intent to harm him, he just needs the intent to convey to that person that he's going to commit a crime against him.
Sure, absolutely. And I think that given Johnson's own testimony, that he was not in fear. He believes this was all a staged incident. He believes that that statement itself was made just to set this scene that he was somehow the victim for purposes of the eviction case. You know, those statements will likewise come in. And his, oh, yeah, I was somewhat afraid, but, you know, what I really think was going on here and what I believed at the time was that this was all staged. This was just an incident he was setting up to set me up for purposes of the eviction case. So again, I don't think that rises to the level.
Counselor, can I ask you something? We're definitely going to start by determining whether there was sufficient evidence. And if there's insufficient evidence, then you win and your client can't be retried.
Sure.
I could imagine someone, especially someone like your client, who's already successfully completed probation, not wanting a result that would involve a retrial, prefer to just have an affirm to a retrial. Obviously, his preference would be an acquittal. So do you know if your client has a position? The Commonwealth is spontaneously suggesting a retrial, and if your client, specifically doesn't want that, that's something we need to consider. Do you have a position on that?
Sure. Quite obviously, before embarking on an appeal in any case, in fact, given the length of time it takes for an appeal to make its way through the system, conversations are clearly had with clients, which are obviously not something I'm privy to discuss with this court. However, clients who proceed with appeals in situations like this where their probation is completed and they are then faced with the prospect of having another trial, consider those things. And in this case, Mr. Tartaglione firmly believes that there was insufficient evidence and that he did not intend to do it. So the appeal is not only given that the case is resolved and the probation is over, but it's a matter of principle that he should not have been convicted of this in the first place because there was no evidence that he intended to harm him or had the ability or current ability or intent to do so. So that's the basis of the appeal. The sufficiency of the evidence should not have been convicted and gone through this in the first place. With that, I have nothing further. If you have no further questions.
All right. Thank you, Counselor.
Thank
We'll
you.
hear from the Commonwealth now. Whenever you're ready.
May it please the court, my name is Alyssa Almeida, Assistant District Attorney from the Plymouth County District Attorney's Office, appearing on behalf of the Commonwealth. While I'm not the attorney that wrote the brief, I'm here to argue the case and answer any questions that the court may have. It is the Commonwealth's position that where there was sufficient evidence to convict the defendant under Mass General Law 275, Section 2, for threat to commit a crime, this case should be remanded in light of the decision in Counterman v. Colorado and Commonwealth v. Cruz from the Massachusetts Supreme Judicial Court, and double jeopardy does not preclude retrial.
What do we do with the fact that Counterman was decided prior to trial?
Yes, Counterman was decided in 2023. Trial was April of 2024. It appears that none of the trial attorneys, the judge, nobody brought up Counterman. I think there was a gray area at the time, whether that fifth element that requires the mens rea, whether it was implicit already in the jury instructions, whether we needed to include that fifth element. It was not discussed at the first trial.
But wouldn't we be in a substantial risk of miscarriage of justice posture?
I don't believe so because
In other words, where it wasn't raised at trial,
right.
and in fact, it wasn't raised until the Commonwealth filed its brief, wouldn't we review the issue under the standard of whether or not it poses a substantial risk of a miscarriage of justice?
I was under the impression that it was harmless error beyond a reasonable doubt review. Under that standard, I guess you would consider whether including that fifth element or not would materially influence the verdict. I would argue that it would.
Well, argue that it would. Why would it? When his obvious intent is to get the victim, Mr. Johnson, to back off, wouldn't he have to try to convey something to him? Know that he's trying to convey something for this to make sense at all?
Yes, so the mens rea is a reckless standard, and we do see at the trial where he says that his intention in making the statement was to, quote, fend off Mr. Johnson from further aggression. That that rises above the reckless standard. It even shows that he had purpose in his actions, and I think it's really an issue for the jury to be able to decide whether he had that mens rea or not in
If it
completing
didn't
his
matter,
actions.
If there was no other inference to be drawn about what the intent was here, except that it was at least reckless for the defendant to say what he did, would we then have to reverse, even if there was the lack of an instruction?
If there was sufficient evidence, then we could reverse and remand for a new trial. If not sufficient evidence, then defendant wins.
So Cruz defines that reckless intent as being that the defendant is aware that others could regard his statements as threatening violence and delivers them anyway. How can we conclude that the defendant's statements, based on the video and based on his testimony, are anything other than threatening violence to the victim? He's raising a self-defense claim, essentially. So isn't the point of self-defense or, appropriate threatened force in self-defense, how can that be anything other than satisfying the fifth prong of Cruz?
I think you have to look at the context and history between the defendant and the victim. They had a previous history of aggression. Since COVID, they butted heads for about 4, 5, 6 years. He refused to vacate. They were standing in close proximity. So I think looking also at the context, the court would need to do that to come to the full conclusion.
Anything else, Counselor?
It's really our position that, would you like to hear the argument on sufficiency, or or just for new trial?
It's up to you.
Yeah, I think the sufficiency of the evidence, I disagree. It was there. We look at whether a threat existed, and we can distinguish from Alif and Shali and say that our case is even more convincing, where in those cases, words alone were watch out, counselor, and drop the charges. Those menacing words alone didn't amount to anything. And the courts in those cases found that sufficiency did exist, and there was a threat, and there was intent. Here, when we look at the words alone, it's completely different. I'm going to beat the F out of you. Those words alone do convey a threat. Then you add in the context, it becomes even more convincing than cases like Shali and Alif, where the words alone don't necessarily mean anything. Watch out, counselor, drop the charges. As to intent and ability, the defendant and the victim lived in the same home together, meaning that it could have happened in the future. It could have happened right there. There's no requirement that he beat him and bury him in the backyard right there. He could have done so in the future. He has keys to his house. So it's the Commonwealth's position that there was sufficient evidence under these circumstances to find that defendant had the intent and ability to make a threat and carry out the threat, whether it be now or in the future.
Should it matter to our analysis at all that the defendant hasn't filed a motion for new trial, arguing that his trial lawyer was ineffective for not asking for a counterman instruction and instead raising a self-defense claim?
I'm not sure that I can answer that question.
All right, Counselor.
Yeah.
Thank you very much. Congratulations. We're very happy to welcome you to the ranks of our advocates before this court. I remember my first argument 25 years ago. I didn't go as long as you went, so you should feel proud. So thank you both. I'll call the second case, Commonwealth versus FUNCHES, number 24P477. Counselor, whenever you're ready.
Thank you. Justice Hand, Justice Ditkoff, Justice Grant, good morning. My name is Mike Maloney. I represent DERUNN FUNCHES. Mr. Fuentes was convicted in 2022 of 2 separate 209A allegations. I'd like to address A, the first 209A violation, and then B, the second 209A violation. Some of the arguments will overlap, some of them will not, Your Honors. Specifically, the first one, which was the violation that he was convicted of, was a non-violent, non-threatening Instagram post, specifically wishing the alleged victim condolences for the untimely passing of her family member. It's defense's position and the appellant's position that the court erred when the judge, acting as the gatekeeper during the trial, during the jury trial, failed to preclude overkill and the cumulative aggregate effect of enormous amounts of prejudicial information with very little probative value from allowed it to be presented. Specifically, the court erred when it allowed a federal indictment, not just the cover page, mind you, but all 8 pages with dozens of lines blacked out to be presented and allowed as an exhibit before the jury.
What was the other evidence to show Slim Deals as a nickname? The victim's testimony and the indictment, right?
That is correct. The victim's testimony, the indictment, and evidence of the Instagram posting itself that showed Slim Deals.
Okay, but that was the posting was what was at issue for the authentication. The authentication was the victim's testimony and the indictment, correct?
That is accurate, Your Honor.
And the judge offered defense counsel the opportunity or the alternative of stipulating to Slim Deals as a nickname rather than the indictments being introduced. Is that correct?
That is a fair assessment, yes, Your Honor. I believe Your Honor just hit the second of 3 prongs I wanted to bring to the court's attention. The third, again, number 1, was the fact that the federal indictment, all 8 pages were introduced with dozens upon dozens of black lines being blacked out. Again, this was a non-threatening posting made via Instagram from Slim Deals. Number 2 was the fact that the Slim Deals, complete with a picture, alleged picture of my client, Mr. Fuentes, was also included. The third being that the court erred in allowing prior bad acts of Mr. Fuentes, which appellant finds specifically contentious because the prior bad acts were for the same violation with which he was being charged.
What prior bad acts came in?
The previous 209A violations, sir.
What do you
The fact
mean?
that these were not just prior bad acts to show character or propensity, they were actually the same charge with which he was being charged.
You mean because both 209As were tried together?
Excuse me, sir, could you repeat
Because
that?
both 209A violations were tried together? Is that
That is accurate, sir,
that's
yes.
the prior bad act?
I don't know if I understood your question, but dockets.
So it seems like, that seems like a joinder argument, that they shouldn't have been tried together. Oh,
Your Honor,
Are you saying that the prior bad act that shouldn't have come in was that there shouldn't have been information about the Instagram post in the same trial as the Juneteenth incident? Or are you saying that the victim's testimony that their relationship had become toxic was an improper prior bad act?
I'm saying prior bad acts regarding previous 209A violations should not have been allowed.
where did those come in?
Could you please rephrase the question, sir?
Where did those come in? I didn't see any evidence of that before the jury at the trial.
It was a one-day trial, sir. The previous 209A violations came in.
Well, as I understand it, the Commonwealth moved to admit them. There was an incident in Brockton where the defendant had allegedly slashed the victim's tires.
She was acquitted of, Your Honor.
Correct. And Judge Coffey ruled that because of that acquittal, the Commonwealth could not get in the underlying facts because, in fairness to the defendant, The jury would have to find out that there was a separate trial and he was found not guilty, so it just complicates things.
Agreed, Your Honor.
So it doesn't appear to me as though there was any testimony before the jury about the facts of those prior incidents. And if there was, and you're aware of somewhere in the record that I've missed, please tell us.
No, Your Honor. I'm not aware specifically, but again, the fact that Mr. Funches was previously tried and acquitted, and the fact that it was referenced during the trial itself on a subsequent case where he's facing the same allegation 2 separate times. Again, if it...
Did the jury know it, though?
Ultimately, yes.
How did the jury learn that?
The prior bad acts were referenced by the Commonwealth during the trial itself, sir.
Where? I didn't see that in the transcript anywhere.
Your Honor, I'm not prepared to say what line of a transcript, sir. If I may, move on.
Sure.
Again, the overall theme of the appellant's position at the violation, the alleged violation, was that he made an Instagram post offering condolences. Clearly, if it was him, he was in violation of the 209A. But this is a non-violent, non-threatening offense. From the best case scenario, this is a non-violent, non-threatening offense. The fact that a federal indictment, not just a cover page, but all 8 pages were included, defense finds grossly prejudicial with very minimal probative value. Briefly, if I may, Your Honors, turning my attention...
No indication either of how that indictment was resolved, is there? Am I remembering incorrectly from the...
Your Honor, forgive me, could you repeat that?
The document that the jury was permitted to see that was introduced into evidence that was blacked out except for your client's name and a portion on the last page, if I remember correctly.
That's accurate, yes, Your Honor.
Doesn't have anything substantive left beyond the name for the jurors to see. Is that correct?
I would not contest that, Your Honor.
Okay, so it's the fact of an indictment-related document. It's not even necessarily clear what the...
Well, I would agree with that.
Correct?
Defense would agree with that position as well, Your Honor, but the simple fact is if it was just being used for identification, hypothetically, under that scenario, 1 page would be sufficient. But the fact that it was 8 pages, this was done for prejudicial effect. And again, the probative value, identity was not in question here. The victim testified. The idea, the moniker of Slim Deals was already in evidence. The fact that
But your client was still making that a live issue, whether Slim Deals that sent the text was the same person as your client, correct?
Your Honor.
Right?
That is accurate, yes.
So the Commonwealth was entitled to try to prove that your client was Slim Deals.
I would agree with that position, Your Honor.
And wasn't limited simply to one form of evidence. It wasn't there's no per se rule that says once someone testifies to a certain fact, there's no other evidence that can come in about that, correct?
Your Honor is correct. There is no specific rule precluding that. I would suggest, however, that the judge has a role as a gatekeeper in any trial, Your Honors. And the fact that 8 pages came in was unnecessary and grossly prejudicial.
But he asked her to admit fewer than 8 pages, right? They said, I understand that trial counsel moved to preclude the introduction of any of that document. Ultimately, the judge ruled that it could come in, but there was no request to limit it in any way other than all in, all out.
Your Honor, again, I would agree with Your Honor's position. Again, defense's contention here is that there is a role of a gatekeeper to ensure that the probative value is not outweighed by the prejudicial effect.
Are you familiar with the Collins case that came down a couple weeks ago in the SJC where the court held that a redacted copy of a conviction was properly admitted for the limited purpose of showing that the defendant had been convicted of a felony and therefore was ineligible to have a license to carry a gun? I was wondering if you have a way of distinguishing that and whether or not you're arguing that this judge didn't weigh prejudice against probative value or didn't give sufficient limiting instructions.
I appreciate the question, Your Honor. To answer it directly, I'm not familiar with the Collins case that came out 2 weeks ago. If I may briefly transition to the second component of defense's position. Again, there were 2 separate convictions here. Number 1 was for the Instagram posting. The second was for the Juneteenth incident. appellant's position, defendant's position is consistent with the memorandum that was provided to your honors by my brother late last night. Specifically, Commonwealth Malloy, 44 Mass Appellate Court, 306-1998. Failure to prove notice and or knowledge that an extension is fatal to the charge of violating an abuse prevention order at trial. In regards to the chronology, if you will, of these two allegations, despite the fact that dockets 21-039 and 22-022 were joined in the West Roxbury District, the latter predates Malloy, the second does not. And it's defense's position that because Mr. Fuenches, there was no evidence that Mr. Fuenches was served in regards to the extension of the 209A specifically, that would be fatal to the Commonwealth case in regards to that allegation.
As to which allegation?
The second one.
The Juneteenth?
Yes, Your Honor.
Is there any inference to be drawn from the fact that the first allegation was still pending at the time that the second one took place?
Any inference, certainly I would concede that any inference could be drawn during the trial itself in regards to an 802 revocation, but I would suggest at this point that issue would be moot, Your Honor. If there are no further questions.
Sorry, just a second, just writing.
Sir.
I had a question about the record. The record appendix contains the police reports that underlie the incident. And my understanding is that parties stipulated to the testimony of two police officers and the judge read what they have testified into the record. How were those police reports in the record? Were they marked as exhibits at trial? Or are they only in the record because they were attached to the complaint or something?
They were attached to the complaint, is my understanding, Your Honor. And specifically, that was referenced during defendant's memorandum as one of the four prongs of the argument in regards to how the court aired the cumulative effect, if you will. Not overly unique, but specific to Mr. Fuenches' case. I'm sorry, did I interrupt, Your Honor?
Well, my question was, are you arguing that what the judge read into the record was not a complete version of what was in the police reports?
No, I'm not arguing that it was an incomplete version. In this matter, during the trial, it was defense who summoned in the police officers, but the Commonwealth who released the police officers. As a result, defense requested a one-day continuance due to court congestion, which should not ever be a reason for denying someone.
Right, and then Judge Coffey said, well, maybe the parties can stipulate to what the police witnesses will testify, and defense counsel said, okay, that sounds like a meaningful solution. And then she described what the stipulation would be, and defense counsel said, actually, yeah, that works.
Yes, this was in regards to the difference between the alleged victim's testimony that regarding Instagram versus Facebook, which has the same parent company, but different direct messaging platforms.
But I understood it to be about the Juneteenth incident because the two officers whose testimony was stipulated to did not include Officer Parham, who took the report about the Instagram versus Facebook. I don't see in your brief anywhere that says that Officer Parham, the defendant needed to continuance to call Officer Parham.
If I understand your question correctly, Your Honor, you're asking, was there any other evidence that was introduced of the officers aside from what was relayed to the jury from the judge pertaining to the two reports that were authored? Is that accurate?
No, what I'm asking is, what is there that was not relayed that the record shows that would have prejudiced the defendant? What was missing? So in other words, the judge left a page out of the police report when she read them into the record, and had they been there in person, they would have testified to what's in the missing page of the police report.
I appreciate the question, Your Honor. I really think this perhaps emphasizes one of the differences between trial court and appellate court. Specifically, some of the dramatic effects between a victim saying Facebook direct messaging one time versus whether we're in fact Instagram direct messaging. The purpose of summoning the officers from the trial attorney was to emphasize and highlight the fact that these were inconsistent statements made by the alleged victim. The reason for the continuance by trial counsel was to emphasize that point in large part. When the continuance was denied by Judge Coffey, he was forced to essentially just deal with these 2 points that were relayed to the jury.
I understood the issue about the 2 officers whose testimony was stipulated to be about the Juneteenth incident and whether or not the defendant had been there for an hour.
Fair enough, Your Honor. That certainly could have been emphasized as well. My reading of the police reports was in regards to the point I just referenced. Can I elaborate or answer any other questions, Your Honor?
I'm good. Thank you.
Thank you, Your Honor.
All right.
Thank you, Justice Ditkoff. Thank you, Justice Hunt.
Counsel. We'll hear from the Commonwealth now, whenever you're ready.
Good morning, and may it please the court. Charlie Marshall on behalf of the Commonwealth, the appellee in this matter. I'm also joined by trial counsel, ADA Laura Drohan, who is present. And I'd also like to acknowledge the presence of Ms. Latrina Hunter, who is the victim on both counts at trial on this matter, who is present in the courtroom today as well. I'll start with what I see as the first issue in this case, that being the decision by the trial judge, Judge Coffey, to admit this federal indictment. So I believe that Judge Coffey did analyze this correctly as bad act evidence under 404B, although it's not typically what you would expect for prior bad act evidence. But even so, our argument is essentially that the probative value, although somewhat and arguably minimal, did still outweigh it.
Well, let's have that argument. What is the probative value of this? I don't see any.
So the probative value, and I believe Justice Hand sort of indicated this, was as corroborating evidence further connecting him to that moniker Slim Deals and adding another pebble.
How does it corroborate that? So a federal prosecutor asserts that he's also known as Slim Deals. Why is that evidence that he goes by Slim Deals?
Because I do think that this record itself, the federal indictment, classifies as a public record, thus falling within the public record exception to the hearsay rule, and does make that document, as well as certain facts asserted therein, admissible as fact for the purpose of attesting that he is at least
What
connected.
fact is asserted by a caption that says DERUNN FUNCHES, a.k.a. Slim Deals? What facts asserted?
Essentially the fact being that he has been connected to that moniker in some way or form. I realize that the document itself does not provide any sort of context for how he was associated with that name, but I would suggest that goes more towards the weight rather than the admissibility, because I do think
If you had
it still
indicted
is.
this case, could you have indicted it as DERUNN FUNCHES, a.k.a. Slim Deals, and then introduced the indictment that you wrote as evidence that he went by Slim Deals?
So the indictment, no, would not be admissible into evidence. As Your Honors all well know, a complaint, an indictment itself is not evidence.
So why is a federal indictment evidence? What's the difference?
I think there's a distinction. So that indictment is not a piece of evidence for that federal charge, for that case, and could not be used as such. But I don't think the fact that it's an indictment precludes its admission in a separate trial, such as this. I actually think it weighs in favor of its admission, because if we're talking about hearsay and jointedly confrontation type issues, one of the major factors and concerns is the purpose for which this document was drafted. Whether it was made and whether the facts therein were made for the purpose of being admitted at an eventual trial and proving a fact at trial. This was not. This was a document made by the federal prosecutor and by the court conjunctively when they adopt this.
That means it's not testimonial, but isn't it hearsay? Aren't you saying that some AUSA thinks that he goes by the name Slim's Deals and wrote a document that says that?
So I think it's an exception to the hearsay under the rule I noted, and I would liken it to a lot of times in these circumstances, and especially with the facts of this case, we see it with restraining orders. Obviously, there was a restraining order issued in this case under the same exception. Returns of service, where there's not really, there are facts on that restraining order or abuse prevention order that is submitted, those documents are quite clear in the case law, are not considered hearsay. They are considered an exception under the public records exception. This is akin to that, where on those documents you see names, you see date of births, you see addresses where there's no real basis for origin for where that information came from, other than somebody put it on that public record at some point, not for the purpose of trial, but for the purpose of, in a restraining order or return of service, effectuating a statutory obligation to provide notice to whoever is being served with that and attest that they were in fact served as under statute. Similarly here, just because there is a moniker that associates him with this moniker Slim Deals, just because there's no basis or background for how that made its way onto the public record, it is still a fact on that public record that was not made for the purpose of trial, that was not made intended to be submitted at trial, and I believe that 803B, or 803.8, I believe, under the Mass Guide of Evidence, makes that fact admissible for the fact of the matter.
What do we do about the fact that in closing argument, your friend called this indictment a court finding?
So I get the panel's concern, if that was a concern, indicating that it's a finding.
I don't know about the panel, but it's certainly my concern.
Yes. Whereas, no, I agree it's not a finding. That is not the correct term. However, my memory is that that was defense counsel that made that representation. What I do want to point out is, and I think this is relevant to the prejudice versus probative argument that is the main subject of the defendant's brief, the Commonwealth did not mention this in closing at all. Ultimately, turning, if I may, to the probative in the Prior Bad Act analysis of this, again, the probative value.
So page 149, prosecutor's closing argument. You also have the court finding that tells you he goes by Slim Deals as well, a nickname.
So I would concede that calling it a finding was an error. I would say that that was very unlikely to have swayed the jury one way or the other. Ultimately, while this may have had minimal prejudice, and I'll concede that it didn't have much, essentially its relevance was a stone going towards the confirming circumstances that he actually did author this comment, which is the subject of the second claim on this appeal. However, any potential prejudice was, I would say, not only minimized, but basically rendered void based on the steps that were taken both by the prosecutor and by the judge in this matter. So it was never referred to an indictment in front of the jury. They were never told that. I will say to Justice Hand's question to defendant, whether or not what exactly was redacted and what wasn't, there was a caption at the top of the indictment that did state that it was the United States verse, and there was a CR number, and there was the word violations, and then his name and the moniker. Other than that, it was completely redacted, so very heavily redacted. There was a contemporaneous limiting instruction immediately upon its admission into evidence, where the judge specifically stated that it was not being introduced to show that Mr. Funches has bad character or he was involved in any other criminal activity, and you are not to accept it or draw any of that conclusion. That is a powerful contemporaneous and limiting instruction, and the jury is presumed to have followed that instruction. There's no indication in the record in any jury questions that they did not follow that instruction, so I don't think there's any suggestion that they would have used this for any other purpose other than the extremely limited purpose of adding one more pebble on the stone of a confirming circumstance that he was using this moniker and going by Slim Deals, thus corroborating the Instagram comment as having been authored by him. Also, counsel makes an argument essentially that this was cumulative and unnecessary. However, the case law is very clear. The question is not whether the evidence was necessary, but only whether it was probative and whether that probative value outweighed its prejudicial effect, which I state that it did. And it is not a foundational requirement for admissibility of Prior Bad Act evidence that the Commonwealth show that it's necessary or that there is no alternative means to prove the case. So there is no requirement that we needed this evidence, and especially, as Justice Hand indicated, this was who authored this comment was a live issue at trial. I would suggest it was the biggest issue for that count, that first count. And so even if minimally probative, it was important to just add a stone as the confirming circumstances, the case law. There's no one way to do it. It's a piling of circumstantial evidence, and so it was at least relevant in that effect. And to the extent that this panel is concerned about the hearsay and whether or not this actually was admitted in error for reasons aside from the probative versus prejudice analysis, I would suggest that it does not amount to reversible error where there was other evidence, obviously, of connecting him to this, and that this very likely did not sway the trial. I do think that's a natural transition to the second claim here, which is the confirming circumstances and whether or not there were confirming circumstances for the judge to find that a reasonable jury could find more likely than not that the defendant authored this comment, because that is the standard, at least for admissibility. So our argument is that under Purdy, the controlling case, which I know this court is aware of, that essentially all we need to show is confirming circumstances, no one way to do it, that it was more likely than not that he authored it. What we had here was essentially that the victim and the defendant had communicated over Instagram for a period of about 8 years leading up to the date of the offense when this was sent. Going all the way back to 2012, the two had known each other since they were teenagers and were in a dating relationship. They lived together for a period of time, and over that time, the two would often communicate and like on each other's posts on Instagram. The victim knew that this account was his account from those previous interactions, from those comments, from those interactions on the social media site going back 8 years, which I think is the key confirming circumstances here, how familiar she was with this account, because oftentimes in these social media cases, that is what makes the difference. She knew him to go by Slim Deal. She testified to that effect. She knew that that was a moniker he used, that the profile picture in the account depicted the defendant, and at least a small picture of that profile picture was submitted to the jury as well. And lastly, and very importantly, the content of the message itself. So the notification she received was commenting on a post that she had made commemorating her recently deceased uncle, in which the defendant commented, "I know I'm supposed to speak to you, but I apologize, I know I'm not supposed to speak to you, but I'm sorry, rest in peace." I would suggest that that is knowledge specific to the defendant and goes a long way in confirming that it was him that sent it.
Just, I have a question about the record. When you say the profile picture depicts the defendant, you're talking about the little one in the little circle?
Correct, yes.
The man who's sitting in the chair with the red background, that's the uncle?
Yes. The small circular photo would be the profile picture, and I realize that based on the quality of the photo itself, it's hard to actually look at that and then potentially look at the defendant in court and make the connection themselves, but the victim did testify that it was him depicted in the profile picture as well, so it's not the only evidence. But getting back to that knowledge...
And that little picture next to Pretty Lady 617 is the victim, right?
I apologize, I don't have it in front of me. I believe so, Your Honor, though. Right. And I can reference my appendix quickly.
That's okay. Just trying to get this, I'm not an Instagram person, so trying to get the sense of how it works.
But I would suggest that knowledge is very important. I know there was a recent decision out of this court, I believe it was issued last week, that I believe the majority of the panel sat on, Commonwealth v. John Ecker, that dealt with kind of this specific circumstance and these confirming circumstances. There were a number of cases
It's unpublished, though.
It's unpublished, but I think it's...
Right, so we're not going to rely on it.
Okay, but it does refer to some cases that I would expect this court is aware of that are in fact published. One specifically being, I believe it references Commonwealth v. Welch. That's 487 Mass 425, in which the Supreme Judicial Court called the evidence of confirming circumstances there overwhelming, based on one, the defendant's distinctive nickname, which again is sort of akin here, and circumstances beyond that, specifically one message from the defendant in that case that described how he intended to deliver a victim flowers on Valentine's Day, which is content specific to the relationship, which I would suggest that we have here. There's also another case that, although not cited in my brief, I would want to point the court's direction, which is Commonwealth v. Alden, which is 93 Mass App Court 438, where it dealt with the authenticity of...
Could you give that to me again?
That is Commonwealth v. Alden, ALDEN, and that's 93 Mass App Court 438. That dealt with the authenticity of a text message, and one of the specific factors that the court relied in saying that it was sufficiently authenticated was the fact that the victim and the defendant in that case would communicate over these numbers that sent the message for a period over a year, and that was a large factor in the familiarity with the number and going towards the fact that it is more likely than not that the defendant was the one who authored the relevant text message in this.
So doesn't, I know I'm not supposed to speak to you, also show service?
So it does for the first incident. The reason for our letter last night is essentially Malloy makes clear that after a subsequent annual extension of an order, that there is no presumption that because there's no rule in operation of law that it is automatically going to be extended, there can't then be a presumption that the defendant, if they were not present for that, and there's no other evidence of service or constructive knowledge or constructive notice, that it is insufficient and it is detrimental to that charge, which is why we sent the letter. The letter in Commonwealth v. Malloy specifically only applies to the second count, the Juneteenth incident, because that happened in June of 2021, whereas that annual extension hearing, which the defendant was not present at, as every indication on the RO, was
What
a
if
month
the
prior.
defendant isn't present at the extension hearing, but he receives notice of it and doesn't show up? Are there any cases subsequent to Malloy that talk about that?
So I would say that is a different circumstance. I'm not familiar with the case, but I don't think it's determinative here because we didn't have any other evidence presented at that trial that he had any idea about that extension hearing, or at least that he had any idea about the result of that extension hearing. And I see that my time is up, so if there's no more questions, I'll rest on my brief.
All right, let me say a few things. First of all, I appreciate getting the heads up from the 16L letter, but a new issue really needs a brief, so I'd ask you both to submit supplemental briefs on this new issue by January 11th, up to 10 pages. We'll send a written order, but just so you can get...
January 11th?
July 11th. July 11th would be better. Yes, January 11th is a little farther out than we want. July 11th, no more than 10 pages. We'll send an order, but so you can get working on that. Just on this issue of the Malloy sufficiency of the notice for the second argument. In addition, I'd like to welcome the trial prosecutor. Always good to see trial prosecutors. It's very helpful for the court. Hopefully you'll do an appeal yourself sometime, and we'll get to see you directly. And with that, I'd like to thank both lawyers for a very interesting case. We'll take under advisement.
Thank you.
All right, I'll call the third case, Commonwealth versus BAEZ, number 24P546. Counselor, whenever you're ready.
Thank you, Your Honor. Christopher Nichols with the District Attorney's Office of Hampden County. Good morning, and may it please the Court. The Commonwealth is here on appeal of a motion, on the allowance of a motion to dismiss for alleged violation of General Law, Chapter 263, Section 5A. That statute affords arrestees, people who've been arrested for operating under the influence, the right to notice that they have a right to an independent medical examination. And that right comes in the two forms. It comes in the form of oral notice, and it comes in the form of written notice. In this case, it's clear that the defendant received oral notice from the Chicopee Police Department that he had a right to an independent medical examination. The issue is the written portion of that notice. Here, it's the case that there was no posting of that right on the wall of the Chicopee Police Department for the defendant to see, and so in that sense, the written notice component was not provided in that regard. But written notice can also come in the form of being provided a copy of the 5A rights. And in this case, the defendant was given a copy of those 5A rights to sign while being booked. He did sign that copy. I believe it was Commonwealth's Exhibit 2 during the motion hearing and the proceedings below. And the question is whether or not, having been presented with that copy of the rights and then it being subsequently taken away while he was in the cell for approximately 5 hours was sufficient notice. And the Commonwealth's view is that it was. The court ultimately decided that it wasn't and allowed the defendant's motion to dismiss. The court cited essentially two things when it decided to dismiss the case. The first was its concern that the Chicopee Police Department didn't have the posting of the rights on the wall of the Chicopee Police Department, and I think it said the court said something to the effect of, at some point there should be compliance with the statute. Gruska, which was a case that the Commonwealth cited in the proceedings below, was decided in 1991, and now it is now 2024. So I suppose one of the reasons why the court allowed the defendant's motion to dismiss was to punish the Chicopee Police Department for not having the poster of the 5A rights on the wall. The Commonwealth takes issue with that because at the time of the hearing and at the time that the court allowed the motion to dismiss, the Chicopee Police Department had come into compliance with Section 5A by having the rights posted on the wall of the police department. So in that sense, the court was curing an illness that no longer existed, because at that point...
Couldn't the judge also have been explaining why strict compliance was being required in this instance, or underscoring the fact that strict compliance is required?
If I may, Your Honor, I would dispute whether or not strict compliance is required. Strict compliance is certainly preferred, and we wouldn't be here if there was strict compliance, but it isn't absolutely necessary, and there are some exceptions to strict compliance. And this brings the Commonwealth to its second issue with the motion judge's rulings, which is that we didn't really get a whole lot of specificity about why the motion to dismiss was allowed. There was no analysis, for example, of whether or not the noncompliance with a written component was not prejudicial under the circumstances. There was no analysis about whether or not the weight of the Commonwealth's evidence was so overwhelming as to kind of negate the potential prejudice that the defendant suffered from not having been provided the written notice. And there was no exploration of the alternatives other than dismissal. It was, I think there's a violation of 5A, and and went straight to dismissal, which isn't the way that the courts have asked us to.
I didn't see any place where your predecessor asked the court to consider lesser sanctions. Did I miss it?
The Commonwealth's argument after the hearing was not particularly robust. What the Commonwealth did ask the court to do was take a look at the Gruska case as kind of an example of how to treat a violation of the 5A rights where oral notice is given but written notice is not.
Gruska was a no sanction at all case, right?
Gruska was a no sanction at all case, yes.
I just don't see where you preserved the question of a lesser sanction. Certainly preserved the question of no sanction, but...
Well, Your Honor, I would point out that the motion judge has discretion to decide what the sanction is, I think irrespective of what the Commonwealth asked for.
Sure, but obviously didn't exercise it, and can you appeal on something you didn't raise below?
Well, assuming I can't, Gruska would still stand for the proposition that dismissal was not the appropriate remedy.
Sure. Can we discuss that? Because you raised something very interesting, which is, the question on whether the oral reading was enough to inform the defendant of his rights, such that we know being given a written notice wouldn't have added anything. But we don't have any finding on that. We do have a video. So how do we proceed? Is this a remand? Is this for us to figure out from the video how effective that was? What do we do?
So, Your Honor, I think a remand may be appropriate, and I say that because that seems to be what happens in other cases where there's a 5A violation and the reviewing court doesn't have enough information at the appellate level to make a decision. So I think that happens in a variety of cases. In Andrade, for example, I believe the court decided that a remand was the best outcome in that circumstance. And I think in Hampe as well, I would, in fact, I can point to the language of that. It's 524 in Hampe. It says, In this case, the judge concluded that there was not overwhelming evidence of the defendant's guilt, but from the judge's written findings and conclusions, we cannot say what evidence was considered in reaching that conclusion, and accordingly, the case must be remanded for a rehearing. And so, to the extent that it is the case that the motion judge may have decided that there wasn't overwhelming evidence of intoxication, or may have decided that it was not prejudicial under the circumstances. We don't have any of that information in the written findings. What we have is a kind of an admonition of the Chicopee Police Department, again, for a problem that no longer existed at the time, and also a reference to this kind of a lack of a conclusion as to whether or not the defendant was ultimately given a copy after he was released and posted the bond. Which
What does shall be given in the statute mean? In Gruska, the police had the rights in a binder, and they read them to the defendant and showed them to him, but they didn't give him a copy. Does give him mean give it to him and allow him to possess it continuously during the period when he might exercise the right?
I think that might be a decision for the court to decide, but Gruska does seem to suggest that in that circumstance he needed a copy and that what was in the binder didn't count, because the violation
Count or did count?
did not count.
Yeah.
And the reason is because Gruska says that there is a violation of the not giving the written, but nevertheless said that dismissal was inappropriate. So if there was a violation, it wasn't the oral component, because we know that the oral component was fulfilled. It was the written component that wasn't. And if what was in the binder wasn't enough for the written component, then it must be that he needed to have a copy at some point during the booking process, and then probably when he left. Although that does seem a little bit anomalous, because if the written component is fulfilled by a posting on the wall, it is the case that the defendants don't leave the police station with the 3x4 copy of the poster.
What if, this is a hypothetical, what if the police gave the defendant a written copy, and then he had it for a few minutes, but then he's going to be put in lockup, and the police for security reasons, don't want him to have papers in lockup because people have been clogging the toilets or setting them on fire or something? Would that count as giving it to him if they said, here it is, you can look at it, but when you go to lockup, you've got to give it back and we're going to put it in your property?
So in the Commonwealth's view, I think it could, and that's actually what happened in this case, as I'm sure the court knows. He was given the copy, he signed the copy, so we know it was in his hand, at least he had some attachment to it. It was for a short duration of time, that's true, but he did have that copy. And there's circumstantial evidence that he received it when he left, because it was placed with his items into property, and then we know that he obtained his property when he left. The motion judge, rather, didn't seem to think that that was enough evidence to show that he ultimately received the copy, although I think defense counsel kind of concedes that he did receive the copy at the end of the day in the brief, and I think that that is circumstantial evidence that he did ultimately receive the copy. But assuming that he didn't, then the question is still whether or not it was prejudicial under the circumstances, and the Commonwealth's argument is that it wasn't prejudicial under the circumstances, and in that case, dismissal was not an appropriate remedy. So either way, we still get back to this point where dismissing this operating under the influence charge was not appropriate under these circumstances. And I do want to go back to Gruska as a little bit because I think it's the Commonwealth's best case, but there are certain distinguishing characteristics between what happened in this case and what happened in Gruska. In Gruska, for example, I believe there was a little bit more attentiveness from the officers with the conveying of the rights to the defendant. I think they said something to the effect of, these are important, you should probably be paying attention to this. So that's not what happened in this case. In this case, the defendant had the form, was given a pen, he signed the form. He didn't ask to look at it anymore, but it seems to be he had the form or the 5A rights for less time than the defendant did in Gruska. But I'd like to distinguish that distinguishing fact, which is that in Gruska, the defendant, I believe, was concussed. I think he had a broken nose, he had some medical issues, and so we're dealing with a person who at that time maybe needed a little bit more attention from the police department than we had in this case. In this case, and you court can see it because the video's been provided to your honors, standing just a few feet away from the officer conveys orally these 5A rights to the defendant in a language that the defendant is capable of understanding, in a space from which the defendant is able to hear and ostensibly comprehend what the officer is saying, and then is, of course, given a physical copy of those rights to sign, and I'm sure had he, I suppose we don't know, but had he asked, which he didn't, potentially have been able to have more time with that form to review.
So I don't know which way this goes, but I didn't really see any signs of intoxication in the booking video. If you feel differently, here's your chance to tell me differently.
Well, one, I think the motion judge also found that there wasn't a lot of evidence of intoxication in the booking video, and I'm not disputing that finding. But for the Commonwealth's perspective, that doesn't answer the question of whether or not there was overwhelming evidence of intoxication that would counterbalance the potential prejudice of a 5A violation, because there's still all of the evidence that happened at the scene. So we have a situation in which a defendant is caught speeding. I think he's going 15 over. He runs a red light. He has the odor of alcohol. He has the glassy, red, bloodshot eyes. He has slurred speech. His performance in the standard field sobriety exercises tests was I think there were a couple violations. It wasn't egregious, I'll concede that as well. But none of that evidence, what the officer observed at the time of the stop and all the way up into the booking, seemed to have made any impact on the motion judge, who simply references the fact that he looks pretty sober in the booking video and kind of ends the analysis there. But I would suggest that to determine whether or not there was overwhelming evidence of intoxication in this case, which is a necessary part of the 5A analysis, the motion judge should have grappled with some of those facts, and the motion judge did not.
Am I mistaken, though, that the case law requires the consideration be exclusive of observations made by the police? What was the evidence of intoxication, or am I misremembering?
Your Honor, the Commonwealth's view is that that's not the case. And I understand that it is, when analyzing these things, the court has the option, is my understanding of it. And I recite the Hampy in this. And because when it's talking about, for example, the potential penalties the court can impose for a 5A violation, and this is, I think, on 523, strike that, on 524, we believe that the suppression of police testimony regarding events, observations, and opinions after the violation of the statutory right, in combination with an appropriate instruction regarding the existence of the statutory right and the violation thereof by the police, will be adequate in most cases where dismissal is not required to cure potential or actual prejudice to the defendant. And I think what that suggests, Your Honor, is that if the court's going to not look at certain parts of the officer's testimony, what should not be considered is the violation, the facts starting from the violation onwards. But the facts, observations, and testimony and other conclusions that the officer may have come to that preceded the violation are perfectly acceptable for the court to consider, and certainly also potential evidence for jurors to hear at a trial, assuming that the court does find suppression of some of the Commonwealth's evidence to be an appropriate remedy. So in this case, the Commonwealth is asking that the dismissal be reversed, and that should the court conclude that further findings need to be made, that the case be sent back down for those findings.
All right. Thank you, Counselor. We'll hear from the defendant now. Whenever you're ready.
Good morning, and it may please the court. Attorney Matthew Hutchinson for Mr. EPI BAEZ. The decision by Justice Basidis Sanabria-Vega was well decided both on the facts and the law. I would suggest it's improper for the Commonwealth to stay up here to say that their notice was given when the statute is quite clear that there's two parts to it. It's not just the reading of the statute, it's that notice posted on the wall or being handed in person or given to the individual. So I would suggest it's improper for the Commonwealth to get up in here and say where there is such a clear black and white statutory right of what the notice is supposed to be for them to say that notice was given. And I would suggest that the court, Judge Basidis Sanabria-Vega, was very well reasoned in deciding the facts of this case that notice was not given. Specifically, essentially, this is a sign here case. From the findings in her decision, it seems that the paper, and you can see in the video, the opportunity that my client had, the extent that he was given, quote unquote, that paper, essentially he had in his possession for 6 seconds, according to the court's decision. And during that 6 seconds, it seems that the officer even had his hand reaching over the counter, indicating on the line where him to sign. I would suggest that it's far afield from any meaningful opportunity for the statutory notice that's required under 5A. The Commonwealth relies on Gruska to support their proposition that they do not have to give the person notice, and there are sometimes exceptions that apply. Gruska itself, I would suggest, states that strict adherence to the rule is the standard.
Right, but that doesn't mean the remedy is necessarily dismissal. I mean, the police have to strictly comply with the statute, and they didn't back then. But the case law says that the remedy is up to the courts. And there seem to be situations where we don't dismiss. So why under Gruska isn't this one of those?
Well, Your Honor, I would suggest that the court really turned around on that and looked really back to its roots of Andrade when they decided the case of King. And when they were talking about that this right that we have is not akin to a right of a punishment to an officer when we're suppressing evidence, perhaps of a constitutional violation, but what this right is a preservation of evidence. It's a right to make sure that an innocent person or a person doesn't have to go to trial and be found guilty when there was evidence available that could have acquitted him. And essentially that's every single time where there's...
But King says the presumption of prejudice may be overcome by other evidence indicating the omission was not prejudicial in the circumstances. And a situation where the defendant receives meaningful oral notice, and maybe that's what happened here, maybe it isn't, wouldn't that be a situation where it wouldn't be prejudicial in the circumstances, like Gruska seems to suggest?
Well, I would suggest that the rule is strict adherence, but there are exceptions. The exceptions are, like in Gruska, that there could be situations, I would summarize them as exigent circumstances. In Gruska, the police station, the reason why there was no notice posted on their wall, the police station was just built a couple weeks ago. And taking the time to be making sure that he was given the rights, even though the courts ultimately decide he wasn't given that notice, I would suggest it's far different what we have here. They handed him a binder pamphlet and had him read through the right very slowly and carefully, making sure that he had an opportunity to really understand the right he was given. Much contrasted here, again, where it's just a sign here type situation, and where my client had no opportunity to bring the right back with him into the cell to review it on his own or have an opportunity to review it on the police station. So whereas, yes, Your Honor, correct, I would suggest there are some exigencies for every rule there's an exception, and I would suggest that there should be some wiggle room, again, in a case like Gruska, where the police are actually going out of their way, that they're handing him a binder, they're going through it line by line, and, it's somewhat excusable that there was no notice on the wall that, the police station had just been built. But here, Your Honor, there's no such evidence. This police station, there's no evidence that it wasn't just built, and really, I would suggest watching the video, it really was indifferent to my client's right to that independent medical examination.
I'm struggling with what would have been different if they had given him a copy and let him keep it. I mean, he didn't make bail until like 9 a.m., like 5 hours later, so I'm not sure how he could have executed this right anyhow.
Well, it's an important question, Your Honor, because the notice is an all-important part of this procedure, because once my client is properly on notice, then it turns to him to invoke that right. And once he does, Your Honor, that starts a quicker process in order of getting the bail clerk there. That's talked about in the King case, that essentially once the 5A notice requirements are met, then it's on the defendant to then invoke that 5A right, and there's a very quick bail magic that essentially puts it back on the police department at that point to get the bail clerk down there as quickly as possible. So whereas here, the Commonwealth did not properly notify my client, it's not fair to say that the police, that it wasn't on him to notify them that he wanted the bail clerk down there, because he just wasn't properly notified of the right for him to do so. Moving on. And I mentioned that there are exigent circumstances, but there's also what the case talks about where, there's overwhelming evidence of intoxication. I would suggest in a case like this one, where the defense is able to establish that there is a violation of the 5A right, that there would be a burden shifting, that the Commonwealth would be their burden to thereafter prove that my client was so under the influence of alcohol that these 5A rights weren't noticed. But we did put on some evidence of that fact, and I believe the court rightfully so found that in the video that my client was not clearly intoxicated. And this right is specific to the individuals like my client, where there may have been this medical evidence that could have clearly established his guilt, his innocence or guilt before the court. It's this fact-finding, it's this preservation of evidence that's really important to the court. And so whereas we lost that, not because of anything my client did, but because the statutory rights were not followed pursuant to 5A, pursuant to Andrade, pursuant to the King decision, I would suggest that, as I initially stated, the decision by Justice Posada-Sanabria-Vega was both well decided on the facts of the case as well as the law.
What's your best evidence of deliberate or intentional misconduct by police?
Your Honor, I would suggest that the court has moved away from that standard, that the King case really looked at that standard and moved on from it, again, highlighting the fact that this is not a rule of suppression, not a rule of punishing for constitutional violations, but this is a rule to protect, to preserve evidence that would not otherwise be preserved if not for this right. So it's a very special rule. It's a very special carved-out privilege. So I would suggest go back. It's that strict adherence in any case where there is an overwhelming intoxication. Essentially, that any person that's able to effectively, where there is room for them to disprove or deflect the charges, that's really when the right comes into part. And whereas Justice Vega is saying that my client is not clearly intoxicated, I would suggest that it clearly falls within that category.
All right.
With that, I'd rest my brief. Thank you very much.
Thank you, Counselor. I know you're a very experienced trial prosecutor, but we're very happy to have you up here in front of us for the first time. It's actually very helpful to us.
It's quite an honor. Thank you.
To have trial prosecutors who, know what's going on in the trenches. Thank you.
Doesn't matter to me.
All right, I'll at least try to call the next case, adoption of child, 24P 1294. Looks like we got everyone. And for the audience, after this case, we'll take a 15-minute break. Let me just remind everyone that this case is impounded. We won't be using any named civilians. We'll use phrases like father, mother, child, no initials, just descriptors. Counselor, whenever you're ready.
Thank you, Your Honor. Good morning, members of the panel. My name is Natalie Hoppel, and I represent the appellant father in this appeal. Your Honor, father's appellate arguments focus on two themes, family and fairness. Father's brief addresses three main issues: the tribe's right to notice if the subject child is part of a federally recognized Native American tribe, the role of the child's family both before parental rights are terminated and after termination, and the fairness of the lower court proceedings.
Can I ask you a couple of questions about, just as background to your first point? With respect to the ICWA argument, is the father contending that he is a member of any tribe?
Your Honor, my client has not contended that he's a member of any tribe, but I can address the concept that father does have standing to raise this issue before this court, if the court would like me to do so.
I would.
Under the collateral attack statute, which is 1914 of ICWA, that statute allows any party to one of these cases and the tribes to bring forward a contention that either the notice requirements, which is 1912 or 1911 or 1913, were violated. In addition, the federal regulations...
Well, it has to be any parent from whose custody such child was removed, and such child is Indian child. So we can't get there without finding she's an Indian child, right?
I think, Your Honor, that you have the ability to ask that question if the notice and the inquiry did not occur. So if there's a default in 1912 at the lower court proceedings, I don't think that you can say that because it's not an Indian child and you have to prove there's an Indian child, you don't get to bring the collateral attack statute. The collateral attack statute, I believe, when read in whole with the statute and the regulations, allows parties to come forward with subsequently learned information that the child is a Native American child and attack.
But they would have to have that. I mean, if they couldn't come in and say, we want to challenge this, even though the child is not Native American.
I think, Your Honor, what I think the court may be getting at with these questions is whether or not there's a burden on the parents at this stage in the proceedings to bring forth additional information that would verify or justify their assertion that ICWA is applicable to this case. But what I would suggest to the court that the way that ICWA was drafted and the way that the regulations are read is that this inquiry should have happened in the lower court proceedings in a more robust manner.
How do we know it didn't happen in a robust manner?
I think, Your Honor, when we look to the docket and we look to the concept that was put forth by Justice Massing in adoption of URSA, the idea that the docket has a finding that's reflected on it on the record that the court has done the inquiry at the outset.
URSA doesn't say it has to be in the docket. It mentions it was in the docket there. It just has to be on the record, which it would be on the tape of the first
Yes,
hearing.
Your Honor, but I think, again, the other concept that I can bring in terms of what's on the record and not on the record is that the record is deficient. The tapes were not part of the record that was assembled on appeal. But what I'd like to talk about as well.
I mean, you mean the clerks, no one ordered the transcript of those hearings?
Correct, Your Honor.
But you didn't order those once
No,
you
Your
got this
Honor.
case?
No, Your Honor. My
Don't
siblings
you
at the
need,
bar.
don't you need to order that to tell us that something was done wrong at a particular hearing? Don't you need to give us a transcript of that hearing so we can see whether it was done wrong or not?
I think, Your Honor, that the concept of the transcript not being part of the record, I think that shifts the burden upon my clients again, or my client to establish that the court did or did not do an ICWA inquiry.
Why isn't it the appellant's duty to present us with a record to review the claims of the appellant?
Your Honor, I would assert that under URSA, where the URSA court stressed that the docket entry needed to have a finding on it, that if the court made the inquiry, the court didn't necessarily make a finding as to how the inquiry was made, whether these parents in this particular case had capacity to understand what the court was asking, whether or not any of the other participants at the 72-hour hearing were questioned. There's nothing in here to indicate in the docket that the court made
But
an
when there's
ICWA
nothing in the
determination.
record, don't we presume it was done properly? I don't know why we presume it was done improperly without a transcript or something in the record saying it was done improperly.
I think, Your Honor, where the record, there's nothing in the findings that talks about an ICWA inquiry being commenced. There's nothing in the docket that reflects that the parties were inquired as to their status, whether or not they had any information. The participants at the emergency custody hearing, my client was not added on to this case until much later.
We don't have the transcript from that hearing either, right? The first
No,
hearing
Your
you filed,
Honor.
we don't know whether the inquiry was given then to your client.
Correct, Your Honor.
So as I understand it, your client was not on the child's birth certificate originally, and then about 7 months after the child was born, paternity, after this care and protection proceeding had already been progressing, your client was identified as the father, and there were several hearings then that involved your client that we don't have transcripts of. Should we just assume that even though there was all this talk about is he the father, is he on the birth certificate, has he established paternity, that nobody said anything about whether or not the child was an Indian child?
I think, Your Honor, when I look at the exhibit appendix, and there's very scant, if any, information in the exhibit appendix, and my siblings and I, through our briefs, we did address what minimal information is in the exhibit appendix. There was conflicting information, and I believe it was on March 10th of 2022 or 23. There was language in DCF's file that was indicating that mother's status was unknown, but then it was a no. So there's conflicting information that doesn't necessarily tell us that anyone went the distance either through DCF or in the lower court to ask these parents and any relatives whether or not this child had any Native American ancestry.
I mean, the court needs to, right? Even if DCF does, that's not enough under the regulations. The court has to make the inquiry, correct?
Correct, Your Honor. So it's a bifurcated approach that ICWA implements under the regulations and that carry out the statute. On the one hand, the department is charged with due diligence in terms of going forward and finding out information. On the other hand, at the hearing, at the initial hearing, the best practice is for the lower court to ask each participant, not just the parties, whether or not anyone has any information to know whether or not the child is an Indian child. So there were 3 other witnesses in addition to mother at the temporary custody hearing. My understanding would be that the lower court judge would be, once they were called to testify, asking each of those participants in the lower court proceedings whether or not they had any knowledge or any information that would show that this child was Native American. Then the ICWA regulation, which is 23107, goes on, and it really states that it mandates that the inquiry should be on the record. On the record, I think that that's subject to interpretation, but from IRSA, we know that a best practice is that on the record would be in the docket as a docket entry and, quote, a finding of the court, so that there is an incontrovertible finding that was made by the lower court judge at the outset that this is not applicable or is applicable. Then the third sentence in 23107A requires the court to go a separate distance, and further along the line in the distance is to inform the parents or the parties, the parents, I believe if there's any interveners that were present, of their obligation. And I would suggest to this court that that includes attorneys, the department's clients, the department's attorneys, anyone in the room, whether or not they've learned of any information that this could be an Indian child. And I think it's important that where this isn't necessarily clear that it happened and that it was recorded and that the lower court judge made a finding that in this particular instance, these parents had the capacity to understand the question and understand what the court was getting at. I think this case is a little bit different in terms of when I will be talking, hopefully, about my client's capacity and the issues that I've brought to the court's attention regarding his capacity during the hearings. I don't have a level of faith that the lower court went ahead and understood, even at the temporary custody hearing, that either of these parents, given their struggles, were in a position to really understand and give what's called a colloquy of their understanding that no, there's no Native American history in our family. And Your Honors, I would just also, in terms of ICWA, in terms of addressing ICWA and the importance, I'd like to focus on the idea of jurisdiction and notice. I've had other arguments with the department where they've let me know that ICWA is burdensome and why are we doing this? There's no point. Nobody's a Native American child. But I look to what the congressional intent behind ICWA was, and the idea that Congress took on a trustee role and delegated that role as trustee as a fiduciary obligation to the state to carry out ICWA, which is to prevent the disbandment of Native American families, to make sure that tribes are not decimated further after what had occurred when the tribes lost a lot of their land and resources. So when I look at my arguments, Your Honors, I tend to see that the department will often tell me that ICWA is overly burdensome. And one of the things that I've tried to look at is why is this the way that it is, and why am I finding that as I'm reading through these cases, I'm not getting a sense, or I have clients that I'm not getting a sense that the lower courts are going through these colloquies on a routine, regular basis to discover this information. I looked up the new juvenile court rules that are going into effect, I believe, on August the 4th. It seems as though there's language now in those juvenile court rules which are intended at the pretrial stage of the proceedings to very much verify that ICWA inquiries have occurred, so Your Honors won't be having me here arguing ICWA arguments at this stage in the game. In terms of father has a right under ICWA, and there's a regulation, and I believe it's 23137. Any party at any point is able to So there's no requirement that his rights under ICWA were violated. Rather, a petitioner may challenge the action based on any violations. That's talking under the collateral attack statute. So where this is an appeal, I would assert to the court that my client has standing, even if it is not him who has the Native American ancestry. He does have the ability to step in under ICWA and raise this on behalf of any other party.
If the child had Native American ancestry,
Yes.
which we don't know.
Your Honor, I don't think that because I represent the father, I'm trying to figure out what I can tell you versus what I know from my client. Because I represent the father, I would say that based upon my pleadings, I would be asserting this under the collateral attack statute and the regulations stating that father has standing to bring this forth because, as you all are aware, mother is not a party to this particular appeal. So without going beyond this record, mother is not participating in the appellate process as a part of this appeal. So I think that might be as far as I can go. And I think Your Honor's question in terms of is the child Native American, that is the question. One of the problems that are faced in these cases is that if the department isn't reaching out to a sufficient number of family members and inquiring, sometimes the parents are not the person or the individuals, especially these parents given their circumstances, to be able to weigh in on ancestors. They are likely not the family members that are what is commonly referred to as the record keepers. We all have family members that might have an idea that they love ancestry, or they like to go and look up where we're from, who we are, and find, I guess, gravestones and work with genealogists and whatnot. These parents were not necessarily the parties who were fit to be able to discuss whether or not, or able to discuss whether or not this particular child is an Indian child. So we don't know what we don't know at this point. And I think that is part of the problem in terms of ICWA's implementation. I did let the court know about a new federal law that's been enacted that Congress seems to be looking at gathering data and information under its funding statutes that's aimed at encouraging, if not strongly encouraging, the states to implement inquiry and notice requirements. And I also, Your Honors, coming here with somewhat of a solution. If there is, where the department's records indicate that it was unknown, mother said no, maybe these parents were not the parents who would know if this child was Native American. There is a portion of the notice regulation that if you cannot identify a tribe, so if you can't get to the point of saying X, Y, or Z tribe is the tribe we need to notify, there is a procedure where if you identify as many ancestors as possible, you can then send a notice to the BIA. So we're talking...
I have a hypothetical for you.
Yes.
If the parents are asked at the initial hearing, is there Native ancestry? And they both say no. And then, say after trial, one of them comes forward and say, I just spoke to my family record keeper and I learned that there actually it is an Indian child or is qualified to be a member of a tribe. What would happen then? Would they be allowed to raise it then?
They would, Your Honor. My understanding under the collateral attack statute, and I will caveat that with some time limits, my reading of the statutes is that they can, at that point in time, within a certain amount of time, be able to bring that forward.
So how is that? So 1914 requires a showing that an action violated a provision of Section 101, 102, or 103 of the Act. Which provision would that be violated in that situation?
Those three provisions, because that's the federal enactment language. It's 1911, 1912.
Yeah, I know, but
Yes.
which one of those would be violated in Judge Grant's hypothetical?
In Judge Grant's, that one would be the notice requirement, because what we're saying here in the regulation is that there's an instruction that's supposed to occur. If you subsequently discover information that a child is Native American, you are to come to the court and inform them. So that would most likely be a post-judgment motion. The other option would be to file a petition to invalidate. That jurisdiction can go to either federal court or any court of competent jurisdiction. The time limits that I understand would apply to this would be up to 1 year after adoption, and I believe there's language in here that I would take from the voluntary relinquishment statutes, which would look at whether or not 2 years has passed before a parent voluntarily relinquished their parental rights.
So which of 1911, 1912, 1913 do you think was violated here?
I believe that it was 1912, and that would be under the inquiry and notice. So you can't get to notice if you're not inquiring. So if the court isn't making a good faith, due diligent effort to inquire and to ensure that whomever is being asked the question fully understands what they're answering to, I think that is upholding what I was talking about, the fiduciary, the trust obligation that Congress has delegated to the state courts. And a lot of this, again, would reduce the volume of ICWA-related appeals before this court, and it would promote finality, which I believe is one of the interests that my siblings will argue before this court in terms of their argument. So what I'm advocating for on behalf of my client is that the formalities weren't met with regard to him, but the formalities that the regulations state are pretty clear, and I think that a good faith application of them would allow identification of Native American children in these proceedings. It would allow us to address the jurisdictional issues that Native American identity presents, and then it would also hopefully reduce the, I'm sorry, Your Honor.
I think we'll have to leave it there.
Yes, Your Honor, thank you.
Thank you, counsel. I understand the department's taking 10 minutes.
Yes. Oh, sorry. May it please the court. My name is Carol Frizzoli, and I represent the Department of Children and Families. On appeal, Father does not challenge any of the findings of unfitness, which ultimately support the trial court's conclusion of termination of parental rights. And just briefly, the overwhelming factors of unfitness included Father's demonstrated pattern of an extensive history of substance misuse, failure to maintain sobriety as evidenced at trial, arrest for drug possession and distribution on the way to one of the trial dates, extensive criminal history, a failure to maintain safe and stable housing, domestic violence, minimally engaging in any services to address any of these issues. In fact, at trial, Father had said that he wasn't ready to take custody of the child. He would need at least 6 months in order to get the house ready with safety, for the children.
Right, but the question here isn't whether the father's unfit, but whether he got a fair determination of that.
Correct. And I believe the two issues on appeal, one I'll first address with respect to the ICWA. First of all, with respect to ICWA, Father raises for the first time on appeal that the trial court did not comply with ICWA, but Father's mistaken here. Number one, it was never raised during the pendency of the case.
Does it have to be?
Even in adoption of Ursa, they mention adoption of Willow, where, yes, if the issue isn't raised. The contention
It seems weird where the obligation of the court is to inquire on everyone whether they have information, that someone needs to object and say, hey, you didn't ask me whether I had information. If no one knows about that and the importance of that, how are they going to know to object?
Well, again, what we do know in this case is we have a record, Exhibit 15, which was unchallenged, which is the department's family assessment, which does basically goes over family history. And what we have is it's not unclear, it's clear from the record that both mother and father identified themselves as Caucasian, and when asked about Indian heritage, they denied any ancestry. So that's what we have in this record. We don't have anything else in the record which says that the colloquy that my sister is talking about was ever done or not done. What we have, it wasn't reflected in the docket. But what we also have is that Father is not asserting Indian heritage, even in this appeal, only that we didn't document it.
But he doesn't have to have Indian heritage. It's enough if the child does, right?
Well, it would have to be him or the mother. Yes, Your Honor, I would agree that if mother had heritage.
If a non-Indian father marries an Indian mother and the child is Indian, the father can raise the ICWA rights even though he himself is an Indian.
Correct.
We're using the term Indian, by the way, because that's what Congress uses.
Yeah. Native American, I don't mean to use the wrong term, I'm talking.
For the gallery, I was just telling them.
So, but in this case, we have affirmative evidence in the uncontested Exhibit 15 that both mother and father denied any Indian heritage. So that's what we have before the court. The issue on appeal is that it wasn't reflected, that the colloquy, that we don't know whether it occurred, whether it didn't occur, that's not reflected in the docket sheet. And that's the only issue here on appeal. And again, we look at adoption of URSA, and in that case, it was an interdepartmental transfer where they had done the colloquy, and one of at the probate court, I believe, and then it was transferred to the juvenile court, and the colloquy wasn't done. And in that case, that's where in URSA, the court went over about, you still need a reason to know, and it can't be more than a bare, vague, or I think the language in URSA is, it has to be more than a bare, vague, or equivocal assertion of possible Indian ancestry without reference to any identified Indian ancestors within a reasonably suspected tribal connection. And there was also, again, we get back to, there was an unpublished decision that I did not include in my brief, adoption of Gordon, which dealt with, again, unpublished, understand it's not binding on this court, but it's persuasive in the sense that the mother in that case was appealing a single justice. It was a late notice of appeal, arguing that she had an ICWA. And again, there was no Native American heritage claimed, so the court said, as a matter of law, it had no consequences. And that's the same in this case, because even if hypothetically the colloquy wasn't done, what we have here is, if there was a violation of ICWA, we have a harmless error argument as well. And again, we're not conceding that the colloquy wasn't done, but even if we can argue, because it's not reflected on the docket, if we want to concede that, this is a harmless error. The purpose of ICWA is to notify the Indian tribe, to give them the opportunity to become involved in the case, and there's a higher evidentiary standard. In this case, no one is claiming Indian heritage. And so, again, if hypothetically the colloquy wasn't done, which we contend we don't concede, again, then what we have here is the only thing that a remand would benefit here would be to send this case back to the trial court to do a colloquy that, and then reflect it in the docket, and it's going to delay the permanency of this child's placement. That's the only one. It's not going to prejudice the parents in this case, because they don't have Indian heritage. It's not going to prejudice the tribes in this case, because again, there's no assertion that there's Indian heritage here. All this is going to prejudice is the child and the child's need for permanency in this case. And she has been in the department's custody since she was born. So the permanency here, that should weigh above anything else. But I also wanted to address the second issue on appeal, which I think my sister didn't get to an oral argument, but it is in her brief about the trial court's request for drug testing during the trial. And in this case, I think the record is clear. This was a father who had not demonstrated any ability to did not have substance misuse. I mean, even in July of prior to trial, he had disclosed that he had used. And what the trial court had observed during the trial was father nodding his head, sleeping. At one point, the phone fell. When he testified, although clear, was, kicking the chair. So the trial court and mother was observed with the same behaviors. The trial court was trying to be fair and said, and father's denial that he said he was sober since July 15th. It wasn't that she was trying to be fair and saying, hey, If you're saying that you're tired and that's the reason, here's a drug test possibility. And she also specifically made the finding that she didn't consider the refusal to take the drug test in her factors of determining unfitness. So clearly, what the trial court was trying to do here was to give that father some rebuttal, be able to rebut the fact of what her observations were, which she's entitled to make based at the trial. So it was fair, and it was not structural error as argued in father's brief. So finally, as to the final issues in the brief, I believe there was an issue on post-termination that visits were not ordered for father. I mean, father sporadically attended visits, very often didn't show. In fact, in one visit, I think in May, it was disclosed that him and mother were under they were under the influence. So it is the department's position that the post-termination visitation order should stand. And finally, I believe there was finally an issue on sibling visitation, but these siblings, the mother's two older siblings, and then the father also had a sibling, they were not, the child has never met these siblings, they were not separated.
Well, the child never came home, so wouldn't have had a chance to meet any siblings, right?
Right, but both of these parents' rights to these children were terminated prior to this child being born, so they were not separated by state intervention. So therefore, the siblings' visitation statute does not apply to this case.
If I could just understand, your point is, even if the child had been released to the mother, still wouldn't have been with the siblings?
Correct.
All right.
So if there's nothing further, I would rest on my brief.
Thank you, Counsel.
Thank you.
We'll hear for counsel from the child.
Still morning. Good morning, Your Honors. Allison Lowe on behalf of the child, who is asking that this court affirm the lower court decrees finding the father unfit and terminating his parental rights. The child is now 3 years old. She has been in the department's custody since birth, and she has been in this pre-adoptive home for the last 2 years. Your Honors, in considering whether the father is fit to care for this child, the paramount consideration is the welfare and safety of the child. And this child has some very specific and specialized needs. She is legally blind. She is developmentally delayed. She struggled to feed, and she is followed by a team of medical specialists and developmental specialists. And in order for her welfare to be protected, she needs a parent who is not serially incarcerated. She needs a parent who is sober consistently. She needs a parent who is awake, alert, attuned, and attentive to her needs. And in this case, Your Honors, the factors affecting the father's fitness clearly showed that he is not a parent who can meet those needs for the child. And with some of those factors being what my sister addressed, and I'll just sort of briefly run through them because I have short time. His long-term sobriety, his continued relapses right up until trial, his serial incarcerations, including for beating the mother of this child when she was 7 months pregnant. And although he did participate in a service that was designed to address domestic violence, in his testimony at trial, he really showed no insight into domestic violence. When asked about that particular incident, he said, well, I admitted it for purposes of the plea bargain, but I'm denying it now. And all that happened was that I moved her away from me during an argument. So I would suggest that that is a woeful lack of insight into domestic violence and its effect on children. He lacked participation in many of the services, and most importantly, substance abuse treatment. He did no substance abuse treatment, didn't go to AA meetings, did not have a sponsor. And he was inconsistent in his attendance at visits with the child, which in a recent decision from this court, adoption of Ariane, was characterized as inconsistent attendance at visits demonstrates a lack of focus on parenting the child, and I would argue it demonstrates a lack of focus on establishing a bond with this child. Addressing the Justice Ditkoff's comment about whether or not the trial was fair for the father, while I do have some comments on ICWA, I'm going to put those second in case I run out of time, but addressing the issue of the drug testing. Certainly the judge was entitled to make observations of the parties during the trial, and her observations are detailed in finding of fact number 26. And she was entitled to put those observations on the record. And she said very clearly, I am very concerned about what I'm seeing in this courtroom. Would it have been better that she not offered drug testing? Perhaps it would have been better, but I think that when...
What would it have been? I mean, shouldn't she have offered the father a chance to dispel?
Sure, I think that that's an argument, as the department made, that it was an opportunity for to rebut or for him to show that he really was only tired.
Well, what if he's so under the influence that he's not competent? Doesn't the judge have an obligation to determine that?
Well, I would argue, Judge, that the father himself and his counsel did not raise the issue of competency, and not that the court can't do that sua sponte, but there were various stages during the trial that father was given the opportunity to consult with his attorney. It happened on the first day of trial when the parties were sent out because there was some interest in an open adoption agreement. That was not fruitful. The trial started, so he was able to consult with his attorney then. During the conversations about drug testing, he was able to consult with his counsel during those opportunities also. I see that my time is up unless there are any additional questions.
Well, thank you, Counselor.
Thank you, Your Honors.
All right, thank you both. Thank you, all three of you. We will take our still morning recess. So it's going to be no more than 15 minutes, but time to stretch your legs and use the facilities if you need to. Thank you.
Court is now in recess.
Nice to meet you, Natalie. Nice to meet you.
This court is now in session. Please be seated.
All right, we are back in session. I'll call the next case, matter of return of a child, number 24P 1190. I understand that you're splitting time equally?
Yes, Your Honor.
All right, Counselor, whenever you're ready.
Good morning, members of the panel, and may
Oh,
it
I'm
please...
sorry,
Yes.
Restart the clock. You guys probably don't need to be told this, but obviously, we're not going to mention the child's name or any of the civilians here. We're going to say child, older brother, uncle. Civilians won't be mentioned. I'm sure you know that, but just to be clear. Sorry. Go ahead.
Good morning, members of the panel, and may it please the court. My name is Laura Openshaw, and I represent the child who is currently 14 years old. I want to start by addressing the issue of whether the Office of Refugee Resettlement or the uncle had custody of this child when the juvenile court issued its first custody order in February 2024. The juvenile court appeared to have assumed that neither ORR nor the uncle had custody at that point, and we do agree with that, based on a reading of the federal law and a reading of the record. Unless the court is also satisfied with that assumption by the juvenile court, then we'll go into...
That was actually one of my questions, so I'm glad to hear that you have a prepared answer for it.
Yes, I do, Your Honor. After the two children were apprehended at the border in April 2023, they were taken into federal ORR custody. It's clear that during the time that they were in detention in Texas, ORR had legal and physical custody of both children during that period of about 3 or 4 weeks. HHS's regulations at 45 CFR 410-1001 make it clear that when an unaccompanied minor...
Could you give that to me again?
Yes, 45 CFR 410.1001. It's a definition section.
001. Okay.
And the regulations define release in that section as being the release of a child to a vetted sponsor. And that is what happened here. The discharge of an unaccompanied minor child to a vetted sponsor. And the regulation is explicit that when that happens, when a child is released by ORR to a sponsor, HHS, and these are the words, no longer has legal custody. So, and that is actually consistent with what we see at page 31 of the record appendix, that the verification of release that is in the record appendix specific to this child states language that ORR has released the above named minor from federal custody.
But wouldn't the person who was the sponsor be able to use that document to get medical care, to enroll someone in school? I mean, wouldn't that be considered a custody document by most state authorities, local authorities?
It would not actually. It's actually closest to, under the laws of the Commonwealth, is a caregiver authorization affidavit, which is pursuant to Chapter 201F. So in Massachusetts, a parent can sign a caregiver authorization affidavit that assigns some of the rights and responsibilities of custody temporarily to another person. That second person doesn't have custody, but they have the ability and they have the responsibility to make certain custodial type choices and duties for the child. Something similar happened here, and the way we know is that although we don't have the specific sponsor care agreement in the record, we do have the federal regulations that talk about the process when a sponsor seeks or is considering seeking legal guardianship. So the regulation is 45 CFR 410.1210B3. This is the section of the regs that is about post-release services. So after a child has been released by ORR to a sponsor, they're eligible to receive certain post-release services through ORR. And those regulations indicate that one of those services is that the provider of post-release services is to discuss with the sponsor and the child the benefits of, I'm reading from the reg, the benefits of obtaining legal guardianship of the child, and if the sponsor is interested in becoming the unaccompanied child's legal guardian, then the provider may assist the sponsor in identifying the legal resources to do so. That suggests that we're kind of in a middle ground. There wasn't a conferral of complete custodial rights to the exclusion of the parent, whose rights have not been terminated and who may later rejoin the child in the United States, potentially. Nor does it indicate that the door is totally closed to that and ORR retains guardianship, although we know that from the regulation about the definition of release. So the juvenile court appears, whether the juvenile court considered this analysis or not, the juvenile court appears to have considered that at the time that the juvenile court made the determination in February 2024 that there was no legal, there was no, that neither ORR nor the uncle had custody of the child at that point, and we think that was, insofar as that part of, that's correct. That leads us to whether IDCS had custody, and if the court is satisfied, I'll move on to the court's, the juvenile court's findings about IDCS. So the juvenile court committed clear error in finding that IDCS, the Indiana Department of Child Services, was the child's custodial agency, and that error rested on an unexplained refusal to consult with the court in Indiana, as well as unreasonable inferences from the evidence that was available at the hearing. We don't know anything about the proceedings in Indiana that gave rise to this order. We only have the order. We do know that in January 2024, IDCS informed its Massachusetts counterpart that the Indiana agency did not have custody of the child. And MassDCF informed this court last month that there's been no word from IDCS since then, despite MassDCF's compliance with the order of Justice Sachs to give formal notice of these proceedings to.
Well, the January 26 affidavit of the social worker said Child Protection Indiana was involved.
Yes,
something there.
So the filing petition by the social worker did contain a couple of references to Indiana child protection. Neither of those says anything about whether IDCS has custody, and the majority of times that child protection is involved with the family, they never take custody of a child, certainly the case in the Commonwealth. And neither of those, even if we credit that we don't know where the statement child protection was involved came from, there was a mention of DCF but not clear, that also is later in the document, but neither of those, it's not reasonable to infer from either of those that IDCS had custody.
So it seems to me, and please correct me if I'm wrong, that the real $10,000 question is, was there a child custody proceeding in Indiana before January 29th, 2024? Because if there wasn't, then the Massachusetts court is the first one to go, and if it is, then the Massachusetts court can't overrule it. Is that correct?
I agree with that. And the juvenile court was given the opportunity and was in fact asked on three different occasions on two different hearings to do exactly that. And the juvenile court had the authority to call to conference the issue under Chapter 7 of the MCCJA. And it's not clear why the juvenile court didn't do that. Then that was error. And we
don't have any, I'll give you a little more time, we don't have any indication, and it's certainly not in the transcripts, we don't have any indication why the judge wasn't doing that?
No, we don't have any indication at all. Despite the fact that the court was asked 3 different times on 2 different hearings, and that was an abuse of discretion, particularly given that the judge acknowledged that there was evidence that IDCS didn't have custody of the child, may not even have been involved with the family at all. And additionally, that the child ran from was last at the home of the sponsor. There was no evidence the child was ever in placement, which would make it even more confusing if there was a custody order to a state child protection agency without a placement. It happens, but it would be anomalous, particularly under the facts of this case.
You can have another minute if there's something else you want to tell us. You don't have to take it.
Your Honor, because of the fact that there's no evidence, the judge made a clear error of law in determining that the extent of her authority to issue a custody order was limited to emergency orders, together with the fact that there is very little evidence in the record, bordering on none, that IDCS ever had custody of this child. We submit that this court can and should reverse the orders of the juvenile court and allow this child to stay in the Commonwealth with his older brother and not be returned to Indiana. If the court, in the alternative, if the court were inclined either to request additional briefing on the issue of federal custody or to remand to the juvenile court for further fact-finding about whether there was a custody order in Indiana, that would be a result that would also be acceptable to us.
I have a couple questions. One is that the judge's findings say that in a December 18th, 2023 home visit with the Massachusetts ongoing social worker, the older brother provided documentation referencing that Indiana CPS had been involved. Is there any documentation, certainly not in the record, but I would think that if the older brother gave the ongoing worker a document showing that Indiana DCS was involved, we would have that in the record. Do you know anything about that?
I don't know anything about that, unfortunately. I think the language was a mention of some Indiana Child Protection Services involvement, but not clear. So it's not at all clear what that document was and what the agency is known, but not known as Indiana Child Protection Services. It's known by another name, so I don't know what that record is.
I wanted to throw out the possibility that we as a court could ask the Indiana court for whatever petition or affidavit or other documentation underlies that Indiana requisition order. And I throw that out there. You don't need to respond to that unless you want to. I just throw that out there as a possibility.
Understood. I don't think I have a response to that, but if I were to follow up in a post-argument letter, I assume that would be acceptable to the court.
Yeah, certainly let us know if you want us not to do that.
Okay, very well.
Can I ask you just two technical questions? One, you represent the minor child. Do you represent the older child or just the minor child?
Just the minor child. The older child is a majority.
Okay. And 209B, Section 3A says when you start a custody proceeding, you're supposed to file an affidavit with all this information. And I didn't see that in the record. I'm not even sure it applies to the child, but I'm not missing it, right?
It's not in the record. I assume it was filed with the Care and Protection petition, and technically this is an appeal from the ICJ where I don't believe that that document is required, but I will, if I determine.
If there is such a document, even if it's in the Care and Protection, I'd like to have it.
Okay, very well. I will look into that, and we'll follow up with a letter if I
Thanks.
obtain it. Thank you very much.
All right, we'll hear from the Deputy Solicitor.
May it please the Court, Anna Lumelski from the Massachusetts Attorney General's Office representing the Department of Children and Families. I want to just start by emphasizing that this is a case where the best interests of the child lean very strongly towards him remaining in Massachusetts. As far as the record indicates, and as far as DCF is aware, there is no one for this child in Indiana. His brother is here. There was a trafficking situation that he and his brother escaped from, and so we would be sending this child back to that state where that trafficking occurred.
How do we know that?
How do we know about the trafficking?
Yeah.
So there is a letter in the record from the federal government. I can find the exact page, but there is a letter identifying that the child was likely a victim of trafficking.
But you may have been subjected.
Yes, and DCF doesn't have more knowledge than that, but there's indication that that is a possibility. And there is no evidence that there is anyone in Indiana for this child, any custodian, whether a custodial agency or any other type of custodian. But there are multiple legal errors that the juvenile court made that would be a basis for reversal here. First of all, the juvenile court appears to have determined that its own jurisdiction was somehow extinguished by the fact that there was this requisition from Indiana. So under the various applicable statutes, the Parental Kidnapping Prevention Act, under the Massachusetts Child Custody Jurisdiction Act, there is a procedure that involves determining essentially which custody order was first in time. And as Your Honor mentioned, there is a proceeding that began in January 29, 2024 in Massachusetts. There is no evidence whatsoever of any custody order.
I take it you agree with my suggestion to your friend that the real question is, was there an Indiana proceeding before January 29th, 2024?
Yes, we agree with that. And there is just no evidence of that at all. And in fact, all of the evidence points to the opposite. DCF had a number of communications with Indiana that are important here. So first of all, in late January of 2024, a supervisor at DCF wrote to a case manager at the Indiana Department of Child Services, and he stated that there is nothing in the Indiana Department of Child Services system showing that this child was ever a ward of Indiana, ever then or previously, and that there's no involvement with Indiana for this child. And then in March of 2024, a DCF supervisor contacted Indiana DCS indicating that the children might be sent back to Indiana, and there was no response.
At least in theory, to get this requisition order, the DCS of Indiana had to file a petition at some point. So they must have had some involvement at some point.
Well, under the Interstate Compact on Juveniles, which provides rules for the process, there's initially a petition, and that petition, and the petition is in the record. The petition.
Where's the petition?
So let's.
There is a petition in the record at RA 18, but that's dated, it's stamped March 13th. Yes. And it has as the moving party the Department of Children and Families.
Yes, and that is confusing. This is the only petition that DCF is aware of, and it is odd that it lists the Department of Children and Families, which is not the name of the Indiana agency, which is called the Department of Child Services. It's
right,
also.
But on that day, March 13th, at the hearing, a probation officer said to the judge, you should have the affidavits before you on the interstate compacts. They were filed earlier this afternoon by ACPO Dawkin, and my understanding is that you cannot sign those. They have to be signed by DCF. So I interpret that petition to be something that was prepared by a probation officer that then at that hearing, the counsel for the boys said he doesn't want to sign it, and apparently DCF didn't sign it either.
My understanding is that this is a document that came from Indiana. This unsigned petition. And
why would it say Department of Children and Families if it came from Indiana?
And March 13th.
I mean, there's no such thing there.
So that is my understanding, and I will, I will go back and look if that's incorrect. But that was my understanding of that document. But in any case, what we have is ultimately what the court looked at was a requisition from the court in Indiana, and that document is supposed to be accompanied by, under the ICJ rules, is supposed to be accompanied by evidence as to why that agency has custody. So under the ICJ rules, Rule 6103, it describes the process in detail, and it says that the court will hold a hearing to determine whether the requisition is proper. And it describes determining proof of entitlement for the return of the juvenile. And then proof of entitlement is defined in the rules as well as documentation or other evidence submitted as part of the requisition that enables a court to verify the authority of the requisitioner to the return of a juvenile. So under the ICJ rules themselves, something beyond a simple requisition is required. And that is not.
So I read it as the court in Indiana was supposed to get a petition with an affidavit and make these determinations. And that stuff was supposed to be submitted. I mean, we should have that stuff. But it didn't seem to me like the Massachusetts court has to make that determination.
So under this Rule 61035, it provides that the state where the juvenile is located, that the court there will hold a hearing. The court in the holding state holds a hearing to determine proof of entitlement for the return of the juvenile.
Where does it say that?
So this is,
The IJC office in the state where the juvenile is located will forward the Form 1 requisition for runaway juvenile to the appropriate court and request that a hearing be held within 30 calendar days of the receipt of the requisition. If not already detained, the court shall order the juvenile be held pending a hearing on the requisition. This time period may be extended with the approval of both IJC officers. I don't see where it says that the court has to hold a hearing on the stuff that Indiana already did.
so point 6, the next one. The court in the holding state shall inform the juvenile of the demand made for his or her return, may elect to appoint counsel. The purpose of said hearing is to determine proof of entitlement for the return of the juvenile. So that's a hearing that's happening in the holding state. And in fact, the court did hold that hearing and did consider whether there was evidence, but made a legal finding that the requisition itself was sufficient evidence to find that there was custody here. And that's clear from the court's decision in the motion for reconsideration as well as in the hearing. The court says, I determine that the fact that there was a requisition, the fact that a judge in Indiana signed this document means that there is proper custody. And that's incorrect under the ICJ rules, which are incorporated into Massachusetts law. So that in itself was a legal error. And as I mentioned, there's a second legal error, which is finding that the court's own jurisdiction had been extinguished in some manner by this requisition, which came later in time than the court's own order of custody here. So those are two legal errors, in addition to what's been discussed before, which is a abuse of discretion in declining to even just contact the court in Indiana and to get a sense of exactly what was going on here.
So of the 4 alternatives under 209B Section 2 for Massachusetts jurisdiction, which is your strongest?
So I think several apply equally, Your Honor. So first, under the default jurisdiction, where it appears that no other state would have jurisdiction under paragraph 1, which does apply here. There's no home state here. And it is in the best interests of the child that a court of the Commonwealth assume jurisdiction. And then what would apply here is the child and at least one contestant have a significant connection with the Commonwealth. So here the contestant would be DCF. And we've described in our brief why DCF does qualify here. And that there is available substantial evidence concerning the child's present or future care, protection, training, and personal relationships. And that is satisfied here. And so, but beyond that, Part 3 would also be satisfied because the child was physically present in the Commonwealth and it is necessary in an emergency to protect the child from abuse or neglect or for other cause shown. And that was satisfied here as well. This child...
But under McDougall, isn't the emergency jurisdiction only for long enough for Indiana to figure out if it's going to assert jurisdiction?
So that's not in the rule. And under the PKPA, which is the federal law that applies to determine sort of between states, the emergency jurisdiction qualifies, which it has a sort of parallel provision about emergency jurisdiction, and that jurisdiction is not discussed in a separate way. So under the PKPA subsection G, it provides that a court of a state shall not exercise jurisdiction in any proceeding for a custody determination commenced during the pendency of a proceeding in a court of another state, where such court of that other state is exercising jurisdiction consistently with the PKPA.
So we're back to the question about before or after January 29th.
Exactly.
There was a lot of discussion in the record about the warrant was recalled. And I'm assuming that means the runaway warrant that was issued for the child in August of 2023?
That was my understanding as well.
Do we know if under Indiana law the issuance of a runaway warrant institute some sort of a custody-type proceeding?
I'm not aware of anything like that. But as mentioned, the Indiana courts, there have been numerous opportunities, both for the Indiana Department of Child Services and for the court system to come in and have their say here and describe, whether something like that exists, and there hasn't been anything like that. And as my sister mentioned, just late last year, based on Justice Sachs's order, DCF wrote to both the court and to the Department of Child Services, inviting them to get involved in this appellate proceeding, and we've heard nothing.
I cut you off before you got to number 4, the appropriate forum. And I guess one of the things I'm wondering about that is, assuming would we need to remand for a juvenile court judge to consider whether changed circumstances, including the older brothers reaching the age of 18 and the younger brother being eligible for services as a victim of trafficking, whether those would be things that should be considered by juvenile court judges here in Indiana under that appropriate forum category?
Well, Your Honor, those considerations can be part of the ordinary care and protection proceeding, which would continue if this court were to dismiss this ICJ proceeding. But nothing about those facts would affect this analysis that we've been discussing, which is really a first-in-time analysis that the juvenile court did incorrectly.
I guess the question is, even if we affirmed at this point where the order was stayed, wouldn't we have to have the juvenile court consult with Indiana to see whether they even want jurisdiction anymore? Because you can always decline jurisdiction under the statute.
Certainly, if this court were to consider affirming, we would request that kind of a consultation, because as I mentioned at the beginning, at this point, based on DCF's understanding, there is no one in Indiana for this child to be sent back to.
Do you have any response to my comment about our possibly contacting the Indiana court and trying to get copies of the pleadings underlying the requisition order?
We wouldn't have an objection to that, but do not think it's necessary. Given the just clear legal error that occurred below, we think reversal is appropriate. But wouldn't have an objection to communicating with the Indiana court.
It's just very unusual for us to not have an appellee here.
Yes, no, I recognize that.
All right. Well, thank you very much. Welcome back to the appeals court. You can tell the state solicitor that we're very happy to get some love from the solicitor's office.
I will pass that along. Thank you.
All right, well, that brings us to our last case, number 24P188, John Doe number 527835 versus the Sex Offender Registry Board. This case is impounded as well. We won't mention the name of the offender or any of the victims of the offender. We'll use offender, first victim, second victim, twin sister, that kind of stuff. Are we ready, Counselor?
Thank you. Good afternoon. Gabrielle Labano on behalf of the Sex Offender Registry Board. The hearing examiners properly determined in this case that Doe's offending behavior suggests a deviant sexual interest in children. That was based upon the evidence here of his convictions and his behavior, and that was also guided by the board's application of the regulatory factors and the regulatory framework, and that was not a diagnosis of a mental health disorder that required expert testimony. The hearing examiner made her findings here based upon the evidence that Doe was convicted of sexually assaulting 2 children. He was first convicted and admitted to sufficient facts of sexually assaulting a 14-year-old girl, to 3 counts of indecent assault and battery on a person over 14. He was actually on probation at the time.
14 or over.
I'm sorry?
14 or over.
Correct, a 14-year-old girl, which under the
No,
board's...
14 or over. It's not over 14.
I'm sorry, 14 or over, correct. And so he was actually on probation for those 3 offenses at the time that he was charged and subsequently pled guilty to sexually offending a prepubescent 8-year-old child. It was based upon that evidence that the hearing examiner made her finding that this behavior demonstrated a sexual interest in children, which is a sexual deviance. This was under the framework and the guidance of the board's regulatory factors. When you look at the board's regulatory factors under 803 CMR 1.33, each factor is talking about variables that research has shown either increases or could decrease an offender's risk of reoffense and or their degree of danger. So each factor is looking at different variables that research has shown is relevant in terms of the analysis of risk of reoffense and or degree of danger. And some of those factors speak specifically to sexual deviance. But when you look at the introductory paragraph to the factors, I'd refer to as the preamble, that talks about the 2 most significant factors, the 2 most significant variables that research has shown is sexual deviance and antisocial orientation. Now, the factors go on to reference those 2 things. Specific factors talk about antisocial orientation. For instance, factor 10, factor 12, factor 13, they reference antisocial orientation and how evidence of an antisocial orientation can increase an offender's risk of reoffense and or their degree of danger. The same thing applies to sexual deviance. There are 5 factors in total that reference sexual deviance. The first being factor 1, which I'll come back to factor 1 because that was not applied in this case, and I think that that's important. But the second factor being factor 3. And what factor 3 talks about is that offenders who demonstrate a sexual interest in prepubescent children, that suggests a sexual deviance and that increases someone's risk of reoffense. And that's what we have here. He was convicted of sexually assaulting an 8-year-old prepubescent child. So factor 3 clearly applies based on his conviction, and factor 3 dictates to a hearing examiner that behavior demonstrates a sexual deviance. There are other factors that go on to talk about sexual deviance as well. Factor 4, which is not applicable in this case, factor 20, and factor 36. So those all were not applicable in this case, but I bring those up to mention that the individual factors.
Factor 20 is diverse sexual behavior?
Right, diverse sexual behavior. So
I got
diverse
the number
sexual
wrong on my
behavior,
notes.
that wasn't applicable here. I'm sorry, Your Honor.
Sorry, I just got the number wrong on my notes, so I got confused for a second.
Oh, yes, factor 20, diverse sexual behavior. So I bring that up because that provides different examples of behaviors that could be considered sexually deviant. So again, the hearing examiner is making this finding in the framework of the factors and being guided by what the factors dictate to her in terms of how certain behaviors, certain things can indicate an increased risk of reoffense or degree of danger. I mentioned factor 1, that I would come back to factor 1. It's important and significant here that the hearing examiner did not apply factor 1, because if she was diagnosing him with something, or if she thought that the evidence suggested that he was a pedophile, factor 1 would have applied. And factor 1 dictates that when someone has a diagnosis of a mental abnormality, such as pedophilia, that increases one's risk of reoffense. So the fact that she didn't apply factor 1 here suggests that, or shows that she didn't diagnose him, that again, she's merely making a finding based upon the evidence and her application of the regulatory factors. Nowhere in the decision does she reference pedophilia, nowhere does she reference paraphilia. She also doesn't reference the DSM-4. And I think that's important because the case that the Superior Court and that Doe relies on, Doe 89230, in that case, the hearing examiner actually diagnosed the offender himself. He referenced the DSM-4, which in that court decision, the court talks about how the DSM-4 provides that it should really only be used by licensed clinicians or people with mental health qualifications. And the hearing examiner in that case ignored that and went on to say that I find that this offender suffers from, in that case it was bipolar disorder, and he found that bipolar disorder, he used the definition of that from the DSM-4 and said that bipolar disorder is characterized by manic episodes, and manic episodes can reflect sexualized behaviors, things like that. So he used that definition and that diagnosis to increase the offender's risk of reoffense in that case. And the court found that that really stepped across the line, and that in that case, the hearing examiner stepped into the role of an expert, made this diagnosis on his own that the DSM-IV specifically said he's not qualified to make. And that, again, that crossed the line. I think that's very, very different from what happened here, where the hearing examiner, again, is analyzing the evidence. She's analyzing the convictions and the behaviors and what that suggests to her, and she's applying those behaviors to the regulatory factors and what the regulatory factors dictate to her in terms of what increases an offender's risk and or danger.
With respect to the behaviors, is there any argument to be made that the hearing examiner's determination that Doe was engaging in grooming behavior is any kind of an expert opinion? Because that seems to be a significant consideration for the expert.
Right, so she does use the term grooming behavior. That's in her findings of fact in the beginning of the decision, where she references sexual deviance and her conclusion that his behavior demonstrates sexual deviance. That's in the end, in her discussion section and her analysis of risk of reoffense. I think that's important because it doesn't appear from the decision that anything about the quote-unquote grooming behavior or test touches played into her analysis of him having a sexual deviance, where she talks about that behavior. She's talking about his behavior with who I refer to as complainant 1, the twin sister, so the sister of victim 2. And you can see in that section where she's talking about the facts, she's sort of grappling with what to do with these facts, because he wasn't charged with anything related to victim 2's sister. But there was certainly evidence that he engaged in inappropriate behavior. He wasn't charged with assault and battery, just simple assault and battery, but he certainly could have been charged with assault and battery based upon the testimony or the evidence that she provided in the SANE interview. There was also evidence that he had made inappropriate and sexualized comments to her and had engaged in a number of inappropriate behaviors with both her and her sister. So in that section where she refers to these behaviors, I think she's sort of grappling with what to do with this conduct with complainant 1 and how to interpret that. And ultimately what she comes down on with that is that, well, there isn't credible or reliable evidence that he committed a sex offense or engaged in sexual misconduct with that victim, that there was certainly an assault and battery, and that was an inappropriate and sexually motivated touching. Which I think is based upon the evidence. That's a fair and reasonable inference from the evidence that, again, he touched her in a way was not with her consent. It wasn't necessarily indecent because of the location that he touched her. In the context of him making these sexualized comments to her and her sister, and him engaging in these other behaviors with her and her sister. And so for the reasons I mentioned, I think the Superior Court and the offender's reliance on Doe 89230 is misplaced. I think this case is exactly like a case that was just decided by this court about 2 months ago, Doe 8703. And I recognize that that's an unpublished case, so it's not binding on this court, but it is persuasive. And the evidence in that case is almost exactly the same as the evidence in this case. In that case, the offender was convicted of touching a very young child. He was
Do you have the docket number for that?
I'm sorry?
Do you have the docket number for that case?
Um,
The Doe number doesn't really help.
I did submit it in a letter to the court.
Oh, you did? I'm sorry.
I did, but I can provide
No, never mind
that.
then.
So it's 105.
Never mind, it's right here, yeah.
Okay.
Okay.
So that was decided by a different panel of this court at the beginning of May. But I think that case is very persuasive because it's almost exactly the same set of facts in that the offender was convicted of touching a very young child. There was also evidence that the hearing examiner relied on that he engaged in a long course of sexual conduct with his daughter, who was an older child. He actually wasn't even charged with the conduct related to his daughter, but the hearing examiner did find credible and reliable evidence of that. And what this court said is that the hearing examiner made her finding based upon the evidence of his behavior and in the context of the regulatory factors, and that was not a diagnosis that required expert opinion. As to the hearsay argument that's raised by Doe, the hearing examiner's findings were based upon Doe's convictions, first and foremost, which I would argue inherently suggests a reliability, particularly where he pled guilty. He admitted to sufficient facts with respect to the first victim, and he pled guilty to the second victim. So I think there's an inherent reliability there in the hearsay evidence where an offender is pleading guilty and there is a conviction. In addition to that, the hearing examiner did describe in her decision all of the factors that suggested to her reliability with respect to both of the victims and complainant one, victim two's sister. So unless there are any further questions from the court, I would rest on my brief.
All right. Thank you, Counselor.
Thank you.
We're from Counselor for Doe. Whenever you're ready, Counselor.
Thank you. Good afternoon. May it please the court. I'm Joseph Schneiderman. With me is Kate Frame. We represent John Doe. I plan to focus my remarks on the issue of surrogate expert. If the court has questions about the hearsay issue, I'm happy to address them. I do want to respond to two things my sister said at the get-go. First, in Doe 89230, the record reflected that the offender there had a diagnosis of bipolar disorder. That's at page 765 of the decision in Doe 89230 in the factual recitation. So there was no dispute about that Doe had that. Here, and Justice Hand had asked about grooming and assault and battery. The problem is, as suggested in the brief, assault and battery on a child is not a sex offense that triggers SORB obligations. So to base an argument on that is problematic because it's conduct that's not within SORB's ambit, which takes me to the heart of my argument, which is the judge here correctly vacated the classification and remanded it because the hearing examiner relied on concepts of grooming and test touching that lacked support in the record or indeed in the regulations. SORB may certainly classify without expert evidence. I don't quarrel with that. But when a hearing examiner employs clinically significant terms, there has to be evidence to support those terms. And to say that the evidence of the offenses themselves bespeak that is at odds with the regulatory fact.
Where did the Superior Court judge mention the grooming and test touches? I didn't see that.
The hearing examiner mentioned that, Your Honor. I'm sorry. That's at record 336 and again at 351, the hearing examiner's decision. Not the judge, the hearing examiner.
Okay.
So the problem is that all of those terms, when they are clinically significant, have to have substantiation. And indeed, the hearing examiner relied on the preamble. There's no evidence, though, in the record by a clinician or of anyone else to make a diagnosis of grooming. The only mention of grooming in the record is at record 98, where it appears in the victim impact statement.
Is there, I haven't looked, does DSM have a definition of grooming?
I'm not aware of one, Your Honor. At least I haven't seen one, and I don't see one in the regs. And SORB scholarship, which they support.
Can you be diagnosed with grooming? I never heard of that.
I've never heard of that either, Your Honor. I would think that makes this error all the more acute here because the hearing examiner said, I rely on evidence of grooming and evidence of test touching. There's no clinician, though, to explain and correlate a link between test touching, grooming, and sexual offenses against children. If SORB had done that, or indeed if there was other evidence somewhere in the record to link that chain, we wouldn't be here. But a hearing examiner, no less than any other agency adjudicator, cannot act as an adjudicator and an expert at the same time. That is ultimately what underpins Doe 89230 going back 45 years. The Supreme Judicial Court has recognized that there is a grave risk of overlap and of unfairness.
Well, so nothing about grooming or test touches appears in the examiner's explanation of why they're doing the classification that she was doing. So where do we find the prejudice from the grooming finding?
Your Honor, the prejudice from the grooming finding is because the hearing examiner relied on it to find a risk of dangerousness. That's at 351.
351?
That's in the hearing examiner. The original recitation of test touches and of grooming is at 336 in the facts. The discussion of why it's significant is it 351 into 352?
Right, well, 351 and 352 doesn't mention grooming or test touches at all.
Just a moment, Your Honor. I'm word searching grooming as we speak. Your Honor, grooming is at record 352 in the middle paragraph that starts with the indecent assaults for which he was convicted caused physical harm to the victims, etc. As discussed above, his acts skirted both sides of the legal line, and the hearing examiner
Yes.
goes on to conclude.
Consistent with test touches.
Yes, Your Honor. I think that error becomes even more pronounced here where you have an adjudicator who is also a trained clinician, Dr. Lori Humbert. She's a psychologist. Whatever expertise she may have, there needs to be evidence to apply that expertise to, and that's the core premise which 89230 flows from. When an agency wishes to engage its expertise, there needs to be evidence, and there just isn't evidence on this record to apply it to. All we have is a victim impact statement. We don't have clinical evidence. Nobody evaluated Doe. And indeed, there's a legitimate question of fairness to Doe here, because if there was some indication that the hearing examiner planned to go in a clinical route, Doe deserved notice and an opportunity to counter that. The SJC has recognized that as recently in 2019 in craft beverages. It's more than just what goes on at SORP here, Your Honor. It is what goes on at agencies generally. So, in the end, Your Honors, there is nothing here, there's no evidence, clinical evidence, for the hearing examiner to apply whatever expertise she has to make these links and to tie them together in a significant way to elevate Doe's dangerous. If the court is looking for a best case, I would point to Morris at 405 Mass, where in Morris, the Board of Registration of Medicine was relying on some ethereal notion of red flags. Morris accords with Doe in 98 Mass App. I know that the court and I have problems with Doe numbers. It's a published decision, though, in 98 Mass App, and it can be found at page 47 of the brief, 98 Mass App 307, Doe 58 574. There is no evidence here to support that. Without that evidence, the hearing examiner should not be able to make and forge these links to venerate Doe's classification, particularly where it has been reaffirmed from time immemorial that SORB has to base their classifications in current science. Unless Your Honors have further questions, I thank you for your time. I ask that you affirm so much of the Superior Court's decision that vacated Doe's classification and reverse on so much of it that held that the hearsay was reliable.
Counselor, I have one piece of housekeeping.
Of course.
So a cross-appellant's reply brief is supposed to be only about the appellant issues. It seemed to me your reply was improper. Am I missing something? Your reply brief, it seems to only raise issues from the primary appellants.
Your Honor, I will endeavor to do that next time. I felt the need to respond, though, given that I had been accused of misrepresenting the record. I very much appreciate Your Honor's point, and we'll take it to heart.
I just wanted to know if I was missing anything about just housekeeping. It's obviously not.
No, Your Honor. We felt that was necessary to respond, given that there was a claim of misrepresentation, and that was what I understood the reply brief to be. So.
All right. It's not important. I just wanted to make sure I understood. Okay. Well, thank you both.
Thank you.
That concludes our cases today. I'd like to thank our timekeeper. I'd like to thank our court officers who had extra duty finding seating for everyone. I'd like to thank all the attorneys that appeared in front of us today, and of course the clerk's office, without which any of this would be possible. I want to invite all the interns and their caregivers to stay. We're going to take off our robes, and I'm going to grab some fizzy water, and then we'll come out and talk to you, and be very happy to do that. And with all that said, court is adjourned until tomorrow at 10 a.m.